Yes, yes.
Oh, that text gonna be denied.
Albert, Albert, di sini. Please. Di sini. Senior level.
For admission, item number 1.
Yes.
Which my last occasion. My first round of agreement was. When the person is. The affidavit on behalf of the state government was filed by the principal secretary. Principal secretary to the Home Department, explaining the subjective satisfaction of the detaining authority. The detaining authority is the Commissioner of Police, which is not permissible as per the law laid on by this court.
You had relied upon 1998
1998
for JLT.
Yes, sir.
The book is available.
We have supplied the list of books. This judgment, I was relying on paragraph 8. Para 8.
Yes, please read.
There is yet another ground raised by the petitioner which relates to non-supply of basic facts in materials considering the grounds of detention by the detaining authority, attributing malafide and non-application of mind to him in challenging his subjective satisfaction. The detaining authority has not filed any affidavit. The affidavit is filed by the successor in office. Ordinarily, the affidavit in opposition must come from the detaining authority. More so in the case where malafide is alleged in subjective satisfaction challenge as in the instant case. There is not even a whisper as to why the detaining authority who passed the impugned order, Annexure E, could not file an affidavit. Assuming he was transferred, yet he was very much available for filing an affidavit. The affidavit filed by the district magistrate, Sri Suinsu, cannot see anything about the subjective satisfaction arrived by the 10th district magistrate Nalbari, Sri Suinsu, who passed the impugned order on Suinsu. Now let us examine the affidavit Worship, this part is not relevant. Worship, may I come to the last paragraph. How can he see about the subjective satisfaction of someone else? Worship, I'm reading from the last paragraph.
Last para.
Yes, how can he see about the subjective satisfaction of someone else?
Now, where is that last para?
Worship, page 42.
Yes.
How can he see about the subjective satisfaction of someone else? Here is a glaring discrepancies. The impugned order of detention speaks of the activities that are prejudicial to the maintenance of public order, whereas the ground of detention referred to security of the state and maintenance of public order. But the order does not refer to security of state, but it could only be explained by the authority who passed the detention order. It is significant to note that the successor in office is a step ahead. What the district magistrate who passed the detention order does not even claim is claimed by the successor in office. As quoted above, he speaks about the satisfaction of the detaining authority. The impugned order, as quoted above, merely states where it has been made to appear to me. There is not remotest suggestion that the then district magistrate was satisfied about the necessity of passing the detention order. The order does not anywhere say that the detaining authority was satisfied on the basis of materials placed before him that the detention order should be passed. It was a compulsive necessity. This cannot be allowed to be substituted by proxy. The subjective satisfaction of so and so cannot be approved by the affidavit of so and so. More so in face of the discrepant nature of the impugned order, which has been passed on mere appearance in not satisfaction. The order is liable to be set aside on this ground as well. Subsequent lines speaks about the non-supply of the documents, so it's not relevant. Here's another adjustment. But it isn't page of this photo on the similar ground.
Yes.
Rightly pointed out on the last occasion.
What is that?
Worship in the paragraph 8 and the last 6 lines, as Worship has rightly pointed out. Ordinarily, the affidavit in opposition must come from the detaining authority, more so in the case where malafide is alleged. Last 7 lines at para 8. In the starting part. Ordinarily, the affidavit in opposition must come from the detaining authority.
You are referring to paragraph 8. Which
Paragraph
part?
8, Worship.
Which part?
The last 7 lines. In order to make out this ground, Worship, malafide should be alleged against the detaining authority.
No, last 7 line in which page? Which page?
Page 42, Worship.
42.
Oh, yes, paragraph 8.
But paragraph 8 ends in page 43.
Worship, paragraph 8, the starting paragraph in the left hand side.
Hmm.
Last 7 lines. The detaining authority. Ordinarily, the affidavit in opposition must come from the detaining authority.
Correct. Yes.
More so in the case where malafide is alleged,
Hmm.
then subjective satisfaction challenge. Worship, in order to make out this ground, Worship, in my present writ petition.
Have you
Yes, Worship.
alleged malafide?
Yes, Worship. Worship, can you come to page number 10? Para 13.
Yes.
Should may I read para 13?
Hmm.
The sponsoring authority in its report dated 24/7/23 has stated that the subject is likely to move for bail and possibility of him being enlarging on bail. The detainee has not moved any court seeking for bail. However, from the grounds of detention, it can be ascertained that respondent number 4 passed the impugned detention order dated 31/8/2023 based on the report submitted by the sponsoring authority. Therefore, the conclusion arrived at by the detaining authority in absence of any supporting materials or records is a mere ipsy which is not sustainable in the eye of law and liable to be interfered by this honorable court.
Hmm.
And in the ground, Lordship, at page 11, ground number B, Lordship. May I read, Lordship?
Yes.
For that, the respondent number 4, without applying his judicious mind and has mechanically passed the impugned detention order dated 31/8/2023 based on the vague report submitted by the sponsoring authority. The subjective satisfaction arrived at by the detaining authority was without any cogent materials. In as such, impugned detention order dated 31/8/2023 is liable to be quashed and set aside by this honorable court and sit the detainee at liberty. This allegation of malafide against the detaining authority, this has to be explained by himself. It cannot be substituted by another authority. Whereas in the instant case, if we see the affidavit filed by the principal secretary, it speaks about as if he has passed a detention order. Roshi may kindly see the affidavit of opposition filed by respondent number 1 to 4. Here it speaks about as if the principal secretary has passed a detention order. Roshi may come to page number 6, para 8.
Hmm.
So may I read para 8?
Yes, please.
That with regard to the statement made in para 14 E to H and 16 of the writ petitions are the grounds of submission of the petitioners are vehemently denied. The answering deponent humbly begs to state that the deponent was well aware about the detainee was in judicial custody and fully satisfied the material placed on record, and after thorough application of mind, the detention order was passed directing the detainee to detain under section 120B IPC. Roship, this is also passed. This statement is was made mechanically without application of mind. The detention order cannot be passed under section 120B. Whereas he has stated in his affidavit, he has stated that the detention order was issued under section 120B IPC, read with 20E and 20E Arms Act. And as per the statement made herein.
Just a minute. Do we have the Arms Act? Kindly give us. Arms Act.
If the criminal case was registered under section 120B IBC and read with 25(1)E and 1(E) of Arms Act.
Hmm. So it was not a provision for detention.
Detention cannot be passed under this. Detention can be passed on. Detention order can be passed only under section 2, clause 2 of.
Maybe this is a typo error.
But this is a part of the affidavit.
It's a part of the affidavit, no doubt. But like you said, malafide has to be pleaded.
Yes, Lordship.
But if you see paragraph 13, which you just read, can you consider this to be pleadings on malafide? Paragraph 13 and
Paragraph 13 in Lordship, yes. Paragraph 13.
as well as 14B.
Yes, Lordship.
See, malafides have to be specifically pleaded. You are just saying that the grounds for detention is misconceived, that's all.
Without application of mind.
Misconceived without application of mind. But that is one thing, but it's another thing to say malafide. Intentionally trying to do something which otherwise would be in principle incorrect. that would amount to malafide.
Yes, Worship.
So
Worship,
that
the
is the
sponsoring authority gave his report that the continuous likely to be reduced on bill. That was that proposal was given without any material to substantiate. And the detailing authority accepted the report of the sponsoring authority without any material to substantiate the said proposal, which was accepted by him.
So the provisions which has been violated is section 25(1)(a), isn't it? 1(a) as well as 1AA.
One A, one double zero. I'm sorry.
Then apart from this, National Security Act also. Give us IPC also. (120B). You have been booked under 120B also.
120 bills. Yes,
Punishment of criminal conspiracy.
yes, Worship.
Okay, 120B, then 25(1)(a) and 1AA. Then you were detained under which provision?
Worship was detained under section 3 clause 12 in National Security Act.
Yes, let us have the National Security Act also. NSA. What is the section?
Section 3 clause 2. Worship. No, the section 3 clause 3. Worship. Detention order was passed under
Section 3, subsection 3.
subsection 3. Worship.
The first detention was passed under what provision? And by
Under
whom?
the clause 3, 3 clause 3. Worship.
By whom?
By the Commissioner of Police.
Commissioner of Police.
Detaining authority.
On the report of the Deputy Commissioner.
No, on the report of submitted, on the basis of the report submitted by the Deputy Commissioner of Police.
Deputy Commissioner of Police, the Commissioner of Police
Passed
passed the detention order under section 3, subsection 3.
Yes, Worship.
Correct?
Yes, Worship.
Then thereafter,
Hereafter, the state government approved the detention order in excess of power conferred under section 3 clause 2.
Section 3, subclause 2.
Yes, Worship.
This was the last order.
That's what.
And regarding the subjective satisfaction, that is under what provision?
Worship, the subjective satisfaction that has to be expressed by the detaining authority,
That is the Commissioner of Police.
Commissioner of Police.
He needs to have a subjective satisfaction.
Yes, Worship.
And thereafter, the matter has to be placed before the state government
Still come for approval.
approval. But further subjective satisfaction is not required by the state government.
Worship, I don't.
So they would rely mainly upon the subjective satisfaction of the detaining
Detaining
authority.
authority.
So is it only a formality? Then it should be given to the government.
After the arrest, if the on the basis of the material placed before him, if the detaining authority is satisfied, he will pass a detention order, and he will forward it to the state government along with the grounds of detention.
Okay.
On basis of the grounds of detention, if the state government is so satisfied, he will approve the detention order in excess of power under Section 3, Clause 2. Thereafter, the matter will be placed before the advisory board. And on the basis of the report submitted by the advisory board, the confirmation order will be issued. In the case the confirmation order has been issued on the basis of the advice submitted by the advisory board,
Confirmation order is to be issued by the government,
state government.
state government. Thereafter, to be placed before the advisory board.
No. On the basis of the advice submitted by the advisory board, the state government will issue the confirmation order.
Okay. And the further period of detention will be determined by whom?
Period of detention will be determined by the state government.
State government. Advisory board can give some recommendation.
Whether it's a fit case or not a fit case to be detained. That will be the report submitted by the advisory board.
No, beyond that, it's a fit case and it should be detained for another 5 months or 6 months.
Worship, advisory board cannot determine the period.
Okay.
It has to be determined only by the state government.
By the state
By
government.
state government.
In your case, it was by the state government.
By state government.
Now, but only thing which you are alleging is that there was no subjective satisfaction by the detaining authority.
Subjective satisfaction arrived by the detaining authority was without any materials. The sponsoring authority give his report that I'm likely to be released on bail. In that proposal was without any material to substantiate, since I've not filed any bail application. And the detaining authority accepted the report submitted by the sponsoring authority.
Secondly, it was not the detaining authority who filed the affidavit.
Exactly.
So how does he know that he has the subjective satisfaction? That is what you're questioning.
That is what I'm questioning. And as per the statement made by him, worship in the paragraph 8, it's worship you kindly see just the one sentence in paragraph 8, page 6 of the state government affidavit. It shows as if he has issued as if the principal secretary has issued the detention order. He wrote in such a way. So the third line, the answering deponent humbly begs to state that. You got it?
Page?
Page 6, para 8.
Yes.
State government affidavit.
Yes.
Like third line. The answering deponent humbly begs to state that the deponent was well aware that the detainee was in judicial custody and fully satisfied the material placed on report. And after thorough application of mine, the detention order was passed directing the detainee to take understands. He didn't pass the detention order. The detention order was passed by the Commissioner of Police. This statement shows that as if he has issued the detention order. So this statement affidavit, he cannot substitute the satisfaction arrived by the detaining authority. When the personal liberty of an individual has been curtailed, they have taken the matter, they have even filed the affidavit mechanically without even the application of mine.
What is this? Fully satisfied the materials placed on records.
Worship,
This records means the,
this it is an exercise done by the detaining authority.
no. Detaining authority, he's just stepping in the shoes of the detaining authority. All right.
Yes, Worship.
And he says that he was fully satisfied.
Yes, Worship.
And what was there to be fully satisfied? Was it the report of the sponsoring authority?
Exactly, Worship.
Do we have the report of the sponsoring authority?
Worship, in my writ petition, Worship, we come to page number 39. This report was submitted to the Commissioner of Police, who is a detaining authority.
Hmm.
Worship, the relevant portion, the grounds on which an arrested person may be detained was stated by page number 48. It's a part of the proposal. Worship, this is a common proposal issued in respect of all the accused. There was 5 accused, Worship.
There was
Five accused. 5 accused in the same case, in connection with the same case.
and this document.
All the 5, Worship. Since in the report, Worship, in the report, he has given the is given the proposal in respect of all the accused persons. And this is a common proposal which is submitted in respect of all the accused
This is the report by the Deputy Commissioner.
by the Deputy Commissioner, the sponsoring of. If you see the third line at page number
48,
page 48,
third paragraph,
third paragraph,
serial number 3.
serial number 3. The subject are likely to move for bail, thus increasing the possibility of them enlarging on bail. In the possibility of the subject indulging in criminal activities is real if allowed to move freely. Thus, every possibility of the subject indulging in similar prejudicial activities, which will be injurious to maintenance of public order, in having the potential to affect the peaceful environment and normalcy of life. This is a proposal submitted by the sponsoring authority. And this has been accepted by the detaining authority. If you see the grounds of detention,
Petitioner is A5.
petition is E5.
A5. Then grounds of detention.
Yes, Worship. Worship, the grounds of page number 40, Worship. By this leader, the grounds of detention was furnished to me.
40,
50.
50.
Worship, in the grounds of detention, that's page number 51.
What is this? 50?
Page 50 is a covering letter. By this letter, the grounds of detention was furnished to me.
Okay.
Page number 51 is the ground of detention. And also the grounds of detention, this has been supported by their schedule. That is at page 52, the schedule.
Security of the state and then maintenance of public order.
So we come to the relevant portion is page number 53, the last paragraph, paragraph 4. Serial number 4.
What is this schedule? This schedule is a part of the.
Schedule is part of a report supporting the grounds of detention. On what basis he has issued a detention order that has been explained in this schedule. The subjective satisfaction arrived by him. In the schedule he has explained.
So these are all a part of the annexure E.
Yes, Worship.
Information. It starts with the grounds of detention,
Grounds of detention.
then
and the
schedule.
Schedule. Worship, page number 53,
Hmm.
paragraph 1 to 2 are the facts of the case.
Hmm.
So it's not relevant. Worship. If we see from paragraph 3 and 4,
Hmm. Just read.
that as per record made available by the sponsoring authority, the subject was arrested for dealing in illegal arms and ammunition and possession of the same, which is a threat to public security and detrimental to the tranquility and maintenance of law and order in the state.
Hmm.
Number 4, that the subject, Lanusanan so-and-so, is presently under judicial custody at Central Jail, Dimapur. If he is not detained, he is likely to indulge in similar prejudicial activities unless an effective alternative measure is called for. Proceed from here is important. On examination of the report forwarded by the sponsoring authority, the subject is found fit to be booked under the National Security Act 1980. Hence, in order to prevent him from indulging in activities prejudicial to the security of the state of Nagaland and maintenance of public order, the undersigned has ordered the detention of the subject under the said act. So, by this statement in paragraph 4 shows that he has issued a detention on being satisfied with the report submitted by the sponsoring authority.
So this is basically his satisfaction.
This is basically a satisfying arrival.
But then you say that this was not, the affidavit was not sworn by him.
Yes, Worship. I've alleged in my writ petition that the sponsoring authority submitted this report without any materials to substantiate the said proposal. And that was accepted by the detaining authority without application of mine.
Yes.
And the subjective satisfying arrived by the detaining authority. This cannot be substituted by the principal secretary. When his action is under challenge in the present petition, the subjective satisfaction arrived by him. It has to be explained by himself, and not by a proxy officer.
Yes.
Here is more clear. That is reported in 2009, volume 4. Volume 4.
For
Page
GLT.
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 216.
216.
216. These are all judgment passed by the ethics court also.
Paragraph. Paragraph.
Paragraph 18, 19, and 22. Your worship's called it, Mary.
Yes.
Paragraph 18. Firstly, if we take the issue of filing the affidavit on behalf of the detaining authority by the officer Sri Additional Deputy Commissioner, Kamrup Metropolitan District, Gauhati, we have no hesitation to see that this officer is not competent to put on record the subjective satisfaction of the detaining authority himself. How can the officer, assuming that he was duly authorized, see about the subjective satisfaction of someone who personally issued the impugned detention order? It ought be pertinent herein to notice that the statement and affidavit made by the officer who claimed to have been authorized incompetent to swear in paragraph 2, which are as follows. So this is the extract of the affidavit shown in that case. So this is not relevant. May I come to paragraph 90?
Yes.
An ordinary reading of the above paragraph of the affidavit would go to clearly depict that the deponent is not competent to speak about the subjective satisfaction of the detaining authority. It is expected that the affidavit opposition must come from the detaining authority. Surprisingly, there is not even a whisper as to why the detaining authority who issued the impugned detention order could not file the response. That apart, how can the office order dated so issued by another officer, not being the detaining authority, be accepted as being authorization letter to file the affidavit by the additional deputy commissioner. Therefore, there cannot be a better example of non-application of mind, mechanical approach, and cavalier attitude shown by the state than the case at hand. So we come to the findings arrived by the division bench of this, that is at para 22. Having regard to the judicial authorities above, and also upon hearing the learned counsel for the parties, we are of the considered view that the impugned detention order deserves to be interfered with on the following three grounds. My case is covered by the first count. Affidavit on behalf of the detaining authority has been filed by an officer of the rank of additional deputy commissioner, Kamrup Metropolitan District, Gauhati, who was not the right and competent person to file the response.
And delay. Next. No, before that, who was the competent authority in this case?
In the present case, Worship, as I submitted, detention order was issued by the Commissioner of Police.
No, in this judgment which you just read. Court says that the additional DC is not the competent authority.
Yes, Worship.
Who will be the competent authority?
Worship, in this case, additional deputy commissioner Kamrup Metropolitan Gauhati has filed the affidavit.
But who should have filed? Deputy district magistrate. Yes, he's the district magistrate.
Yes.
The district magistrate was away. So
He was away.
He
So
was away.
he has authorized the additional deputy
additional
commissioner to file
deputy
the
commissioner. That was not accepted.
affidavit. That was not accepted. Since the detention order was issued by the district magistrate, the affidavit should come from the district magistrate himself.
And next ground, delay of 14 days. What is this? Delay of 14 days.
Worship, that was a fact in this case.
Delay of what? For what?
Delay for disposal of representation.
Representation of
Representation submitted by the detainee.
You must have noticed the author of this judgment.
Worship, in my case,
Forget about 14 days. Even 2 days delay is not tolerated.
Worship, in case of habeas corpus, worship, the number of days is not material, but the explanation given by the authority, that is material. Worship, in my case also, there's a delay.
Yes.
Worship, if your worship is not satisfied with the first ground raised by me, I may be allowed to take the other ground also.
No, I'm not saying anything. We're not saying anything. We are open to whatever you want to submit.
Yes.
All right.
Yeah, worship, I may be also allowed to refer to on the same ground, a judgment passed by the Apex Court in the year 1974.
No, why don't you complete this particular thing? Paragraph 22. There are 3 grounds raised.
Yes, Lordship.
Affidavit not by the detaining authority. Number 2 is delay. Number 3 is compliance of section 10.
The non-compliance of section 10. Lordship, in my case, only the ground number, the first one.
What is section 10?
Lordship, 1610 speaks about the advisory board. Section 10 says that, Lordship,
Of
the
NSA.
ground, yes, NSA, grounds of detention in the representation, if any, filed by the detainee, that has to be forwarded to the advisory board within a period of 3 weeks. In this case, that was not complied with. So that was also a ground taken in the In this writ petition,
But that is not your case in the
but it's not my
present.
case, that is not my case.
But
The
it went to-
second and third ground is not in my case.
Okay.
I'm relying only the first ground.
Yes.
There's an old judgment passed by the apex court on filing of affidavit on filing of affidavit not by the detaining, not filing affidavit by the detaining officer. Lordship, that is reported in 1974, volume 4 ECC, page 455.
Paragraph.
Paragraph 5 on which. Paragraph 5.
Yes.
May I read paragraph 5?
Yes.
Sri Swinsu relied on the mental vacillation of the detaining officer as disclosed in the affidavit in return filed by the state, where in services is struck off after maintenance of supplies. If this reflects the slippery satisfaction of the district magistrate, it is unfortunate. Here, some upper divisional assistant, special home department, has sworn an affidavit, not with personal knowledge, but with paper wisdom. It is difficult to appreciate why, in return, to a role nisi in a habeas corpus motion, it is not thought serious enough, even where liberty of a citizen is chopped off, to get the district magistrate to explain his subjective satisfaction in the grounds thereof. Not even why he is not available, nor the next piece, the oath of a senior officer in the secretariat who has been associated with the handling of the case at government level, mechanical affidavit, miniaturizing the files into a few paragraphs by someone Hindi in the secretary cannot be regarded as satisfactory. This is not a mere punctilio of procedure, but a probative requirement of substance. However, in this case, counsels makes no point about these aspects of the affidavit because the relevant materials relied in the detention order is also admitted in the petitioner's affidavit. Even so, the curious striking off in the affidavit of one ground relied on by the district magistrate in his order is obscure.
Yes.
In my case, Worship, the detaining authority he feels to affidavit and the subjective satisfaction arrived at by him was explained by the home by the principal secretary, which is not permissible in membership. So in this ground alone also, Worship, the detention order may be quashed. And maybe the detainee may be allowed to be set in liberty.
What is the full form of MISA? Maintenance of Internal Security Act. Correct? 1970. It seems in this case, the detainee was transporting 50 bags of rice midnight. And he was he was kept in custody under the MISA Act. Yes.
But when it comes to Worship, preventive detention, the same principle applies.
The detaining authority should file the affidavit indicating his subjective satisfaction. Okay.
There are other grounds also, but
Hmm.
in the habeas corpus petition,
Hmm.
if one ground is violated, the entire proceeding should be quashed.
Where is the impugn order in the writ petition?
Yes, Lordship.
Is it page 55? No, this is the first order.
Lordship, page 49. This is the impunity, first impunity.
49 is by the commissioner.
Yes, by the commission.
Then it went to the government.
The state government approved this detention on 11 September 2020, page 55. This is approval order issued by the state
Approval by the state government.
government.
Then
Then, Lordship, the confirmation order is at page number 66.
66. Confirmation comes after it is given to the advisory board.
After the advisory board gave its opinion.
Yes. And in this order, it says that your detention is still 28th of February.
The date of February.
Your initial detention was from
My initial detention was from 31st August.
31st August 23. In all, how long can you be detained? 1 year.
1 year.
1 year.
One.
Not beyond 1 year.
Lordship, the X makes two.
That's all.
Lordship is satisfied with the first ground raised by me. Lordship.
No, we're not saying anything now. We'll have to hear the other side.
Yes, Lordship.
You mean to say that if the court says no, then you'll again argue with another point?
Lordship, there are other grounds also.
You argue in whatever points you have. We may or we may not be satisfied. Why do you want us to indicate now?
One ground. Lordship, lowly down by the ethics court. Lordship, it says, if the detaining authority
Hmm.
is aware that the detainee is in custody in the detention order, the detainee is likely to be released on bail. That has to be indicated in the detention order.
It has to be indicated in the
In the
detention
detention order.
order
Detention order
by the,
by the detaining authority.
in this case, this page 49.
Page 49 is missing.
What is that? You have some authority on that?
2003, one second. SCC. Page 342. In the present case, if you see the grounds of detention, the detaining authority was well aware that the detainee is in custody. So in such a case, in the detention order, he should indicate that the detainee is likely to be released on bail.
No, if the person is not in detention already, can the detaining authority pass an order asking that he be secured and put in detention?
He may be, the detainee may be under the police custody or under the judicial custody.
Hmm. Correct. So in this case also, the detaining authority was
Aware that
aware that he is under detention,
he is under detention, is under custody.
he's in custody.
To satisfy the, to satisfy lordship,
So what is wrong in that?
that's lordship. Lordship, I'll come to that. Lordship, if you see the schedule,
Schedule,
page number 53. Paragraph 4.
yes,
That the subject so and so is presently under judicial custody at Central Jail.
Hmm.
So by this statement, it shows that he was very much well aware that the detainee was under judicial custody.
Hmm.
In such a case, the Honorable Apex Forces, in the detention order, in the detention order should indicate the detainee is likely to be released on bail. Chip 2003 Olympic SCC 342 page.
Paragraph.
Paragraph 14 also. We have read Rushik, paragraph 14.
Yes.
So far as this question relating to the procedure to be adopted in case the detainee is already in custody is concerned, the matter has been dealt with in several cases where detention orders are passed in relation to persons who are already in jail under some other laws. The detaining authority should apply their mind, ensure their awareness in this regard in the grounds of detention, the chances of release of such person on bail, the necessity of keeping such person in detention under the preventive detention law has to be clearly indicated. Subsisting custody of the detainee by itself does not invalidate an order of his preventive detention. In the decision in this regard must depend on the facts of the particular case. Preventive detention being necessary to prevent the detainee from acting in any manner prejudicial to the security of the state or to the maintenance of public order or economic stability, etc. Ordinarily, it is not needed when the detainee is already injured. This is also important. The detaining authority must show its awareness to the fact of subsisting custody of the detainee and take your factor into account while making the order. If the detaining authority is reasonably satisfied with cogent materials that there is likelihood of his release in view of his antecedent activities, which are proximate in point of time, he must be detained in order to prevent him from indulging in such prejudicial activities. The detention order can be validly made. From here, I'm reading. Where the detention order in respect of a person already in custody does not indicate that the detainee was likely to be released on bail, the order would be vacated. And Lordship, in the second paragraph,
It again refers to some other judgments.
yes, Lordship.
What are these judgments? You have gone through it.
Lordship, in the reference judgment, the principles were laid down. Lordship, in the next line, the principles were set out as follows. Even in the case of a person in custody, a detention order can be validly passed if the authority passing the order is aware of the fact that he is actually in custody, if he has a reason to believe on the basis of reliable material placed before him that there is a real possibility of his release on bail, that on being released he would in all probability indulge in prejudicial activities. Number 3, if it is still essential to detain him to prevent him from doing so. If an order is passed after recording satisfaction in that regard, the order would be valid. In the case at hand, the order of detention in grounds of decision shows an awareness of custody and or a possibility of release. If you see the detention order, page number 49.
Not there. It is not there.
The
But in the what do you call the summary? What was that?
schedule.
Schedule.
Yes.
It is there.
Schedule is there.
It is there in the schedule,
Yes.
but it's not there in the order. But this judgment says that it has to be also reflected in the order. And this is a reference to some other judgment. Let us get these judgments. 6.
And also the principle laid down in here in this list, the number 7 form has referred to 3 judgment. And the principle laid down in the 3 judgment, that has been stated in this very paragraph. The principle was as follows.
Where?
The convention, the 3 judgment principles,
Please use the microphone.
Worship, the principles were set out as follows. So it will be the principles set out in the reference judgment. Worship.
Yes, please read.
The principles were set out as follows. Even in the case of a person in custody, a detention order can be passed if, number one, if the authority passing the order is aware of the fact that he is actually in custody. Number two, if he has a reason to believe on the basis of reliable material placed before him. Clause A, that there is a real possibility of his release on bail. And clause B, that on being released, he would in all probability indulge in prejudicial activities.
See, all these things are there. Only thing is that it is not mentioned in the impugn order
So,
of
Worship,
detention.
that is just a
So-
where the detention order, Worship, where the detention order in respect of a person already in jail custody does not indicate that the detainee was likely to be released on bail. So it speaks about the detention order. Where the detention order speaks.
Now let us get this book. Then 1990, one SEC, 1991, one SEC. Yes, Mr. Lima.
Yes,
Anything else to be referred in this judgment?
you should know. I'm specifically I'm referring only to this the very line where the detention order in respect of a person already in, does not indicate that the detainee was likely to be released on bail. It vacates the detention order. Worship, I'm relying only on that very
Okay,
sentence, Worship.
okay.
Worship, there's also another ground, if Worship permit me.
Yes,
Worship, against the detention order, the detainee has submitted the representation. And the representation was disposed of by the state government as well as the central government. Worship, there's a delay of 12 days
state
Ah.
government as well as
the central government.
central government also.
Worship, under the NSA Act, the central government has the power to, under section 14 clause 1, the central government has the power to revoke even the order issued by detention order issued by the state government. And at the stage of considering my representation.
Where are those? Disposal of your representation.
Yes, Worship.
Have you annexed it?
Yes, Worship.
And you say there's 12 days delay.
There's a delay, unexplained delay.
So delay means there's a period of limitation for disposing such representation.
No, Worship. There's no
Then?
such representation.
Then how do you calculate the
Worship,
delay?
Worship, from the date of my submission of my representation,
Huh.
it will count. Since my representation was submitted to the
It will count subject to there being a period of limitation. You say there's no period of limitation, then how do you say it's
No,
delay?
Worship, it has to be considered under Article 22, Clause 5 of the Constitution of India. It says expeditious disposal. There are several judgments passed by the apex court as well as this high court.
All right, you show me the disposal. Or where is your representation first of all?
Yes, Worship. Worship, my representation is at page number 56.
56.
And this representation was submitted routed through the Superintendent of Jail, Central Jail Demand. It was submitted on 18/9/2023.
And received on that day.
They have received on that day, sir.
Who has drafted this?
This representation was drafted by one of the council of the detainee from
Okay,
Demand.
okay. Because he was in custody, so he couldn't have drafted
No,
himself.
Yes, just the police.
Somebody had drafted him for him.
So should we come to the page number 64. The state government by this order has rejected my representation. You should hear the date is number of days is very important. Representation was submitted on 18/9/2023. And this order was issued on 29 September 2023. After a gap of 12 days. May I read, Worship?
Yes.
The order dated 29 September 2023. Whereas Mr. Swinson, son of Swinson, Worship, that is, Worship, the first paragraph is not in there. The second paragraph. And whereas the state detainee filed a representation, bring for revocation of the detention order passed against him. And whereas the state representative was carefully examined by the state government in all the relevant records, including the methods by which the Commissioner of Police and District Magistrate Dimapur was satisfied with direct detention of Mr. Swinson, were duly examined. And whereas the authority found that there is no merit in the state representation. And now, therefore, the representation submitted by the detainee is not acceded to by the state government. By order in the name of the governor of Nagaland. Worship, in the order itself, there's a delay of 12 days in considering disposing of it. That is not mentioned. And they file an affidavit explaining their action about the consideration in the disposal of representation.
See, disposing representation after 11 or 12 days, how do you say it's delay?
Yes, Worship. Worship, Article 22, Clause 5. It says that it says the detainee is entitled to submit a representation, and that is to be considered expeditious. So there are several judgments passed by the apex court as well as this honorable court, which says, in case of illegal detention, the representation has to be considered as early as possible. And the number of days in considering the disposal, of the representation is not material. But if there's a delay, there should be sufficient explanation regarding the number of days causing this disposal. It may be only 1 or 2 days delay, but the reasons of delay, that has to be explained. Whereas in my case, there's a delay of 12 days by the state government, and there's a delay of 24 days by the central government. The number of days of delay, the reason for delay, that has not been explained in the present case.
See, delay can be, in fact, basically accounted if there's a period of limitation prescribed. If there's no such period of limitation prescribed, how do you say that 11, 12 days is delay?
Yes, Mr. I'll rely on the suggestion passed by the apex court. And Worship, we come to the next order. By this later, the central government has also rejected my representation.
This is in October.
Yes, Worship. 13 October 2023. My representation was filed on 18 September 2023.
Your representation was addressed to the Special Secretary of the State.
Worship, endorsement copy is there. Worship, in the page 62. The central government is at serial number 1.
Okay.
By this letter, it is 13/10/2023. The central government has also rejected my representation.
Yes. So show us how it can be said to be delayed by any authority on this.
Page 41.
2010 volume 5 GLT
GLD is C. Sebelum kau.
page,
Page 41.
sorry,
Oh, 41.
41, paragraph.
Is it paragraph 27, 28, and 29? This is a Manipur case, which went up to the Supreme Court. In order to understand the issue, can we come to from, may I start from para 25?
Just a minute. Para 26,
Kali allow me to start from para 25.
25. Okay.
Those are short paragraphs.
Mm.
Should I start from para 25?
Yeah.
The second issue is that of delay. There has been a delay of 7 days. That is from 9/10/2022 to 16/10/2022. In
Nine-
for
9/10 is what?
9/10/2029,
9/10 is the date of application,
10 of the date of submitting the application
date of application. Okay.
to 16/10/2022. In forwarding the representation of the detainee to the central government. Here has been no explanation of the reason for this delay given by the respondent. Paragraph 26. Article 22, clause 5 of the Constitution of India mandates in preventive detention measures. The detainee should be afforded the earliest possible opportunity to make a representation against the order. With regard to the importance of delay in preventive detention measures under the National Security Act, it has been held by this court in Union of India versus so and so, so and so. There can be no hard and fast rule as to the measure of reasonable time. In each case, has to be construed from the facts of the case. And if there is no negligence or careless inaction or avoidable dictatism on the facts of a case, the court would not interfere. It needs no reiteration that it is the duty of the court to see that the efficacy of the limited yet crucial safeguards provided in the law of preventive detention is not lost in mechanical routine, dull casualness, and chill indifference on the part of the authorities entrusted with application. Where there is reminiscence, indifference, or avoidable delay on the part of the authority, the detention became voluntary. On the specific grounds of delay in forwarding the representation under the National Security Act, it has been observed by this court in so and so that there can be no doubt whether that there was unexplained delay on the part of the state government in forwarding the representation to the central government, with the result that the said representation was not considered by the central government till October 16, 1987, that is for a period of more than 2 months. Section 2 of the Act confers upon the central government the power to revoke an order of detention even if it is made by the state government or an officer. That power, in order to be real and effective, must imply a right in the detainee to make representation to the central government against the order of detention. Thus, the failure of the state government to comply with the request of the Delino for the onward transmission of the representation to the central government has deprived the Delino of its valuable right to have his petition revoked by the government. In the matter before us, a delay of 7 days has occurred in the forwarding of the representation. These may not be inordinate. However, at no stage has there been an explanation given for this delay. The state government or central government has not clarified the same, and thus the delay remains unexplained. In light of the facts that none of the documents relied on by the detaining authority in passing the detention order can be deemed to be pertinent, and the fact that the delay has remained unexplained, there is sufficient ground made out in order to quash the order of permanent detention made against the detainee. The number of these causes is not material, but there should be explanation to the delay cause. The reason of for delay. And Lordship, I may be allowed to refer to another judgment.
So are you, are you saying that there's no explanation in your case also about the delay
Yes.
of 11, 12 days?
That is my case. Another judgment as per ethics code 1999 volume 1 ECC.
Nineteen ninety?
1991.
Hmm.
No, 1999.
Sorry,
1999
1999?
volume 1
Hmm.
ECC 417
Para?
para 7, 8, and 11.
On delay?
Just all on delay. You also received that's on the same principle. The delay it should be explained. So may I start from para 7?
Yes.
It is a constitutional obligation of the government to consider the representation forwarded by the individual without any delay. Now, no period is prescribed by Article 22 of the Constitution for the decision to be taken on the representation. The word as soon as may be in clause 5 of Article 22 convey the message that the representation should be considered and disposed of at earliest. But that does not mean that the authority is preempted from explaining any delay, which would have occasioned in the disposal of representation. The court can certainly consider whether the delay was occasioned due to permissible reason or unavoidable cause. This position has been well delineated by a constitutional bench of this court in so and so. The following observation of the bench can prophetically be expected here. It is a constitutional mandate commanding the authority concerned to whom the detainee submit this representation to consider the representation disposed of the same as expeditiously as possible. The word as soon as may be occurring in Article 5 of Clause 5 of Article 22 reflects the concern of the framers that whether representation should be expeditiously considered and disposed of with a sense of urgency without any avoidable delay. However, there can be no hard and fast rule in this regard. It depends upon the facts and circumstances of each case. There is no barrier prescribed either under the Constitution or the detention law concerned, within which the representation should be dealt with. The requirement, however, is that there should not be supine indifference, slackness, or careless attitude in considering the representation. In worship, this lesson is very important. Any unexplained delay in the disposal of representation would be a breach of the constitutional imperative, and it would render the continued detention impermissible and illegal. Para itu. The position therefore now is that if delay was caused on account of any indifference or lapse in considering the representation, such delay will adversely affect further detention of the prisoner. In other words, it is for the authority concerned to explain the delay, if in disposing of the representation. It is not enough to see that the delay was very short. Even longer delay can as will be explained. So this is not the duration or range of delay, but how it is explained by the authority. This is a finding of the discussion.
Yes.
We are therefore of the opinion that the delay from so and so remains unexplained. In such unexplained delay was appreciated further detention of the detainee.
There was some explanation in this, but it was not accepted.
In the present case, first of all, receipt, I'll take a look to the affidavit filed by the state. Except the date of moving the file.
See, 9/2/99, 9/2/98 to 14/2/1998. The minister was on tour. Was on tour. That's why he could not pass the order. So this was not accepted.
Even though he wasn't there, the reason of delay has been explained. Since that was not explained, the court has not explained. Receipt in the present case also.
Affidavit?
Receipt, I will take a receipt first to the affidavit filed by the state. Can you come to page number 8?
Page?
Page number 8.
8.
B, para B.
Hmm.
That there is no delay in considering or disposing the petitioner's representation. The petitioner represented dated 18/9/2022 was forwarded to the senior superintendent of jail, Senior Chimabur, on 18/9/2023. On the same date was forwarded, as previously. And accordingly, the representative was forwarded before the state government for consideration on 22/9/2023. And on 29/9/2023, the detainee representative was duly rejected by the state government on the ground that there is no merit in the period for consideration. During the process of files in taking decision by the competent authority, it takes 12 days to dispose of reference. Therefore, there is no delay in disposing of the detainee's representation. It is also settled law of principle of law that decision upon consideration of the representation should be independent.
So 18 is the date of the representation. To the special superintendent jail, it was forwarded to the government, which received on 22nd. No, it was forwarded on 22nd.
It forwarded before the state government for consideration.
18 representation was forwarded on 22nd.
And
When-
from 22nd to 29, it was restricted on 29. From
For-
22nd to 29, there's a gap of
No, forwarded means from the jail. From the jail, it went to the government on 22nd.
should be to be
18, 19, 20, 21. 18, 19, 20, 21. 3 or 4 days was kept in the jail. it was in the jail. 22nd it was sent to the government.
to single government.
Thereafter, what has happened is not there.
It's not explained.
Only that 29th was
Only the
rejected.
file movement they have indicated. And as per the judgment which I have just relied on, each detail has to be explained.
What file movement? There is no file movement.
In the second, but during the process of files indicating decision. In the last sentence, during the process of files in taking decision by the citizens. This is not reasonable grounds.
No, these are general statements.
Yes.
File movement means from this table to that table, or who was dealing with that. That is not mentioned. It says that file movement.
So from 22nd to 29th, there's a gap of 7 days. What prevented them? The seven days. That has to be specifically explained. Specifically explained. That is not it. And Rashid, if you come to the affidavit filed by the central government,
Okay. Paragraph.
central government affidavit, Rashid,
Paragraph.
page 3. Under paragraph 4. I'll take your lordship only to one paragraph.
Hmm.
Further, the details of the dealing of the representations are ascended. You got it?
Sorry.
Further, the details of the dealing of the representations are
Yes,
ascended.
yes.
It's just lordship. Last one. A copy of the representation of the detainee dated soon, duly forwarded by the senior superintendent of jail, Central Jail Timor, but later dated 18/9/2023, was received in the section concerned of Ministry of Home Affairs on 5/10/2023. It is very important. A representation forwarded by later 18/9/2023. You have received only on 5/10/2023. Here's a gap of 16 days. Use this due to the modern information, the technology. It can be seen within a minute.
Must have been sent by post.
So that is a careless thing. Well, they are dealing with the liberty of an individual.
How was it sent? No indication.
No, nothing. Even in the state government affidavit is silent. They have not explained this. The period of 16 days.
But what is your explanation? How you have submitted the representation? Addressee, of course, is the government. Then at the end part, it's copied to so and so.
The process of submitting of representation is like this.
Hmm.
That as per the, I have to submit it to the superintendent of jail, the jail authority. Since I am under condition, the jail authority will forward it to the state government. The state government will transmit it to the central government. It is the process.
So all the copies which is meant at the end of the representation, this also will go to the government.
Jail authority will recommend it to the state government.
See, your representation is at page 56 and copies marked at page 62. 1, 2, 3, 4, 5, 6,
9 officials.
7, 8, 9, except for personal copy.
Yes, sir.
All these copies will go to the
State government.
state government through the special superintendent. And the state government will send it to the
Central government.
central government. So how it was sent has not been.
If you see the page number 51,
Hmm.
page number 51, the grounds of detention, the last paragraph. This is the procedure for submitting of detention. Grounds of detention, the last paragraph,
51.
page number 51. You also informed that you have a right to make representation to the detaining authority, central government and state government, through the concerned jail authority. That is an instruction given to me, since I am under custody.
So how it reaches them is not your lookout.
That is not my lookout.
Once you give the representation to the superintendent of jail,
They
matter ends
have
there.
they have to transmit it expeditiously as possible.
Okay. So the affidavit says that it was received only on 5/10.
After a gap of 16 days. then there's no explain about this 16 days. Worship, on this ground also it deserves to be quashed.
It was put to the undersecretary on 7/10.
Yes, Worship.
One day was a holiday, Sunday.
Yes, Worship. Worship, after 5th October, there's no dispute. But within the period from 18/9/2023 to 5/10/2023, there's a gap of 16 days. This period they have to explain. But it's silent in the affidavit filed by the Union of India as well as the state government. This alone is also a good ground for interfering by Russia.
The rest is step by step, isn't it?
But this is a formality, Russia.
Step by step. Only the thing is that why it reached only on 5/10.
Yes, Russia.
That is not explained.
It can be reached within a minute, within a modern technique.
Okay.
Russia, that's all. My submission.
Okay. Mr. Tibais for the state.
Yes, my lord.
All right.
May I please, your lordship?
Yes.
My lord, the counsel for the petitioner has taken 3 grounds,
Yes.
and out of 3 grounds, 2 ground has been submitted beyond the pleadings. My lord.
Okay.
The first ground, the council has taken the filing of affidavit by the detaining authority.
Mm.
Nowhere in the petition, nowhere in the writ petition, he has taken the stand. My lord. And my lord, affidavit was filed on 1st February.
Mm.
And there was sufficient time to counter or to file reply to my affidavit in reply, to my affidavit in opposition. However, the the petitioner has not taken that ground. So, secondly, indicating in the detention order, my lord, that the detainer is likely to be released on bail.
Mm.
That one also in the writ petition, the council has not whispered in the writ petition. So these 2 ground, which was taken by the petitioner, is submitting beyond the pleadings. However, my lord,
No,
for your
just-
satisfaction, my
Just
lord,
a minute.
yes,
One is regarding the detaining authority not filing himself.
yes, my lord.
Then the other one?
That indicating in the detention order that the detainer is in judicial custody and is likely to be released on bail.
Mm.
These 2 ground was not made any statement in the writ petition. The counsel for the petitioner has not taken any ground. And my lord, however, for your satisfaction, my lord, let me satisfy you. Let me justify regarding the filing of the affidavit, my lord.
Mm.
My lord, in the National Security Act,
Mm.
your lordship may kindly see section 3, clause 2 and clause 3, 4. Please kindly allow me to read this section, my lord. Section 3,
Mm.
clause 2, 3, and 4. May I read, my lord?
Yes.
Power to make orders detaining certain persons. Clause 2. Clause 2. The central government or the state government may, if satisfied with the respect to any person that with a view to preventing him from acting in any manner prejudicial to the security of the state or from acting in any manner prejudicial to the maintenance of public order or from acting in any manner prejudicial to the maintenance of supplies and service essential to the community, it is necessary so to do, make an order directing that such person be detained. Clause 3. If having regard to the circumstances prevailing or likely to prevail in any area within the local limits of the jurisdiction of a district magistrate or a commissioner of police, the state government is satisfied that it is necessary to do, it may by order in writing direct that during such period as may be specified in the order, such district magistrate or commissioner of police may also, if satisfied as provided in subsection 2, exercise the power conferred by the said subsection. Clause 4. When any order is made under this section by an officer mentioned in subsection 3, he shall forthwith report the fact to the state government to which he is subordinate together with the ground on which the order has been made, and such order particulars as in his opinion have a bearing on the matter, and no such order shall remain in force for more than 12 days after the making thereof, unless in the meantime it has been approved by the state government. My lord, the commissioner of police or the district magistrate can pass the order, but that order is valid only for 12 days. And that will be forwarded to the state government. So state government will approve that detention order. So without satisfaction, first, here the state government as clause 3, subclause 2, it clearly says that state government, if satisfied. So without satisfying, the state government cannot approve. So state government has produced the materials placed by the commissioner of police, the district magistrate, which was forwarded to the state government, and state government has thoroughly examined, and it was satisfied that that detainee should be detained in under this preventive act. So, my lord, satisfaction can be explained by the state government. It is clearly said that state government, if satisfied with respect to any person. So there is no wrong in filing the affidavit by the state government. And it is not necessary that only the detaining authority should file the affidavit. So, my lord, in regard to the filing of the affidavit in opposition, then the state government has rightly filed and rightly taken decision and approved the detention passed by the commissioner of police. And my lord, in regard to subjective satisfaction also, your lordship may kindly see the ground. Your lordship may kindly see the detention order. Detention order.
The first one.
Page number 55, passed by the state government. Approved by the state government.
Yes.
Page number 55 in the writ petition. Only the relevant para 3. Whereas the state government of Nagaland is satisfied with the view taken by the commissioner of police, Timabur to prevent Mr. Lanosanan Bonganan, son of Tumsa Au, so and so, Mongkolumpa, so and so, Nagaland, Chomukida from acting in any manner prejudicial to the security of the state of Nagaland and maintenance of public order, it has approved the detention order of the commissioner of police. Only after approved by the state government only that detention order has then finally been. So, my lord, in the ground of detention, your lordship may kindly see in the your lordship may kindly see my affidavit in opposition. I've explained the subjective satisfaction. Affidavit in opposition filed by the state. Para 8.
Yes.
Clause A. The following grounds of detention were examined and considered while passing the detention order dated 31st/8/2023, approval order dated 11/9/2023, and confirmation order 17/11/2023. Firstly, the statement of the detainee given
Just a minute. You're reading from?
clause A. Para 8, clause A.
Okay.
Firstly, the statement of the detainee given to the IO reveals the indulgence of the accused in illegal business of selling and possessions of ammunition. In his statement and co-accused statement, it is obvious that the detainee was arrested for dealing in illegal ammunition and possession of the same and was intentionally involved involved in illegal business for his personal monetary gain. Secondly, an investigation reveals that there is strong prima facie case of the detainer where he had acted in contravention of Section 120B IPC, read with 25 clause 1A, 1AA Arms Act, read with 78 NSR. Thirdly, the co-accused in the instant case had admitted that the detainer was the main agent who had connected and arranged the selling of illegal ammunition. Thus, the circumstances of the facts and available records at investigation report of the case clearly reveals that the detainer was main agent who initiated the intentionally for selling of the illegal ammunition for his personal monetary gain. Fourthly, basing on the advisory report submitted before the detaining authority, the confirmation order dated 17/11/2023 was passed by further confirming the detention order, wherein the advisory report has also carefully examined and considered the available materials on record and upheld the opinion that there is sufficient case for the detention of the detainer under the preventive detention law. Thus, it is settled law that detention order under the NSA or preventive detention can be ordered if the person is involved in illegal activities, if the detaining authority is satisfied that it is fit case for the detention with a view to prevent the accused person from acting in any manner prejudicial to security of the state of Nagaland and maintenance of public order. As such, there is no illegality or infirmity committed by the detaining authority for passing the detention order dated 31st/8/2023 and confirmation order 17/11/2023. Rather, taken preventive measure to avoid any further engaging in illegal business and also to prevent a serious threat to the public security and detrimental to the tranquility and maintenance of law and order in the state. This is the subjective satisfaction compel the state government to pass the detention order. And secondly, in regard to indicating in the detention order that the detainer is likely to release on bail. My lord, in the detention order, it is not mentioned. It is not indicated, my lord. But in the schedule, it is, your lordship had already referred that page, which is already mentioned in the schedule. Your lordship may kindly see grounds of detention, page number 53 in the writ petition. That para 4, relevant is para 4. The subject Lano Sanan Bongan is presently under judicial custody at Central Jail. It is if he is not detained, he is likely to indulge in similar judicial activities unless an effective alternative measure is called for. On examination of the report forwarded by the sponsoring authority, the subject is found fit to be booked under the National Security Act 1980. Hence, in order to prevent him from indulging in activities prejudicial to the security of the state of Nagaland and maintenance of the public order, the undersigned has ordered the detention of the subject under the said act. It is mentioned in the grounds of detention. Though it is not indicated in the detention order, the authority has mentioned in the grounds of detention. And thirdly, my lord, in regard to delay of disposing of
No, no.
representation.
What is mentioned here regarding?
Regarding that the detainer was, the state government was aware that the detainer was in judicial custody.
And that is
What-
is likely to apply for bail.
Yes, my lord, since the petitioner, they are saying that in the detention order, it is not indicated. It is not indicated that detainer is in judicial custody and he is likely to release on bail. This sentence has not been indicated in the detention order. However, in the ground of detention, it is mentioned.
One thing is mentioned regarding his judicial, he being in judicial custody,
Yes.
but there's nothing mentioned about his probability of applying bail, isn't it?
Yes, my lord.
That thing is not there.
Yes, that one is not reflected. But however, the detaining authority was aware that while passing the detention order, the detaining authority was aware that the detainer is in judicial custody.
If you come to page 49, this also says that he was arrested. It does not say that he was released thereafter.
Page 49.
Yes.
Detention order.
Detention order. First paragraph says that he was arrested.
Yeah.
So will not this be meaning that he's in custody?
Yes, ma'am.
That could be your argument also.
Yes.
He was arrested.
Yes. Specific sentence has not been taken, but
Although it doesn't say that he's in
Yes.
custody, it says that he was arrested.
yes, ma'am.
It does not say that he was released thereafter.
Yes, ma'am.
So that is, he's in continuous arrest.
Yes.
Okay.
And
Then-
thirdly, regarding the disposal of representation. My lord, representation was submitted on 18/9/2023. Petitioner submitted the representation on 18/9/2023
Hmm.
through senior superintendent of jail, central jail. My lord, there is two ways of dispatching the representation.
Hmm.
One through registered post and one through fax.
Hmm.
And on the same day, that is on 18/9/2023, the state government has received received representation through fax.
How?
On the same day.
How?
They have sent through fax.
Where have you stated that?
That one I have not stated, but it is the fax. It's not been mentioned. So through fax, it was.
Sending by fax is a fact,
Yeah, on the same day, it was.
although you
received.
have not stated it.
Yeah.
Okay, then
And accordingly, the representation was forwarded before the state government, that is the higher authority. Because the representation was addressed to the special secretary home. And the special secretary home received the representation through fax on 18/9/2023.
Mr. Pom,
Yes, my
you
lord.
started your argument by saying that counsel for the petitioner has pleaded beyond his, he has submitted beyond his pleadings.
Yes.
Now you are submitting beyond your pleadings.
Okay.
Because if you come to paragraph B, page 8, representation is 18,
Yes.
18/9.
On the same day, it was received.
No. Representation is 18/9.
Mm.
It was forwarded only on 22/9. So how do you say that it was sent on same day by fax, it was received on 18?
No, my lord, it is that. On 18/9/2023, the special secretary home received the representation on the same day. And special secretary forwarded that representation to the higher authority. That is the principal secretary, additional chief secretary, and the secretary, go up to secretary, chief secretary. Yes.
From where are you saying that?
It
That
is-
is what I'm asking you.
It was forwarded on 22/9/2023
To whom?
to the higher authority, that is the state government. On 22/9/2023, it was forwarded. Received on 18/9/2023 and
Hmm.
forwarded on 29.
Just- No, just read this sentence. It should speak for itself. You see, you need not explain what you have written.
Yes.
There is no delay. Read.
May I read, my lord?
Yes.
That there is no delay in considering or disposing the detainer representation. The detainer representation dated 18/9/2023 was forwarded through the senior superintendent of jail, central jail, Dimapur on 18/9/2023. That is the received date. It was received on 18/9/2023.
Okay.
And accordingly, the representation was forwarded before the state government for consideration on 29/9/2023.
22/9.
22/9/2023. It was forwarded.
And
And on 29/9/2023, the representation was rejected.
so 3 dates.
Yeah.
Is that enough? 18 representation, it was received and forwarded on 22/9 and rejected on 29/9.
Yes.
Is that
It
sufficient?
takes 12 days. It took 12
And
days.
in all, it took 12 days.
Yes, my lord.
Is that sufficient? What transpired between 18 to 22, then 22 to 29? That you have not taken care of. Seeing the special law and seeing the kind of observations made in few cases cited by the learned side counsel for the other side. You just think about that. We'll come back in 5 minutes.
Sir, আপনি লাগে এমএসসি হইয়া আপনি লাগে ইমান ইনভলভ নাই তো আলা সাফিকে
That is your explanation to subsequent to the filing of the writ petition, the filing of the writ para 5
Bisa aja.
Habis fokusnya kronik terpuk bila di dulu. Memang peak fokus itu apa saya kira peak aja dulu. Next time kami dulu kan udah udah.
Representation पर लगी ना.
Akan baru. Nah, first round ini baru sih kan. Second round di judge mundur sebenarnya. Jadi judgment system division order reflect bukan. Section 3 Korea. Iya, tingkat kami belum hati. Ini lagi ini. Ini isu diskusi.
Yes.
Yes, my lord. As I have submitted, my lord, representation was received on 18/9/2023, and it was forwarded to the state government on,
Same day?
yes, secretary,
Same day.
no, 22. 22/9/2023 it was.
No, from the jail, when did it go to the secretary?
From the jail, it received on the same day. That is
Who
18.
received? Who received?
Special secretary home.
Okay, special
Uh,
secretary home received on 18.
Yes.
Then
18
thereafter?
Sunday. And thereafter, on 22/9/22, it was forwarded to the higher authority. That is the date 22/9/2023
That is whom? Who is the higher authority?
to the principal secretary, additional chief secretary, and go up to chief secretary.
Okay.
And it was forwarded into, and the rejection was on 29/9/2023.
Hmm.
So it took 12 days to dispose the representation. Only the important that I have mentioned.
Hmm.
Only the important bit. So there is so many steps to be followed while forwarding the representation.
So why did you only mention the important dates? If there are so many steps.
Yes.
This being a special law, that is why, I mean, you have seen those judgments.
Yes. Ma'am.
Even in some cases, there's been some explanation. That also was not accepted by the Supreme Court. Saying that this is not sufficient. Just because saying that minister is on tour, taking 4 days to give the rejection order is not sufficient. Appears to be quite technical, isn't it?
Yes, ma'am.
Technical, hyper technical, and all that.
Yes, ma'am.
But that is what has been laid down. Anyway, then
So since the petitioner has taken only the 3 ground, I'm justifying that those ground only. My lord, so my last submission is, my lord, there is no infirmity in passing the detention order,
Hmm.
and there is no lapses while passing the detention order.
okay.
That is the only submission. Much obliged.
Also may come to my affidavit.
Yes, your affidavit.
Your Lordship, my lordship may come to page 3.
Yes.
Page 3 of my affidavit, lordship. May I read, lordship?
Yes.
1. I'll read from 1. Comment 1. A copy of the representation of the detainee dated 18/9/2023, duly forwarded by the senior superintendent of jail, Central Jail, Dimapur White letter dated 18/9/2023, was received in the section concerned of the Ministry of Home Affairs on 5/10/2023. So the representation was received only on 5/10/2023.
Hmm.
Thereafter, 2. The representation of the detainee was examined at section level, and after threadbare examination of the material on record, the same was put up to the Undersecretary on 7/10/2023. Thereafter, there was an intervening period of 1 day on 8/10/2023, being holiday on Sunday. Next question.
Hmm.
The Undersecretary, with her comments, forwarded the file to the Deputy Secretary on 10/10/2023. 5. The Deputy Secretary forwarded the file to the Joint Secretary on 11/10/2023. The Joint Secretary, after examining the case, forwarded the file to the Union Home Secretary on 12/10/2023. 7. The Union Home Secretary, having carefully gone through the material on record, including the order of detention, the ground of detention, and the representation of the detainee, concluded that the detainee had failed to bring forth any material cause or grounds in his representation to justify the revocation of the order by exercise of the powers of central government under Section 14 of the National Security Act 1980. He therefore rejected the representation and sent the file back to the Joint Secretary on 12/10/2023. The file reached the section concerned through a aforesaid level on 13/10/2023. Accordingly, the detainee and authority concerned were informed by wireless message number so and so dated 11/10/2023. So the representation of the detainee was received only on 5/10, and from 5/10 to 13/10. There is
How did you receive it?
by post.
By post.
That is the post.
although it's not mentioned. So considering the time taken, it has to be by post. Speed post.
Yes, my lord.
Which one is faster, registered post or speed post? Speed post.
Most probably, I think Lordship, it is registered post because the government, the send the post through registered post only.
Casual attitude ataupun pada customer itu. That is our issue. With the personal liberty of an individual seperti.
You had just mentioned section 14
Yeah.
in what you read. Section is the 14 is the power of the central government
Yes, Worship.
to interfere with the detention order.
You can revoke the order passed by the state government while considering the revenge.
Anyway, I was indicating on the lighter note. Speed post is not what it seems to be. Speed. That actually speed thing is just another word. Never travels in speed. Anyway, in such a situation, are you not required to communicate with the state also that if there's such kind of representation comes, you should give more importance to it and send it to us directly by email or by whatever fax or like that, isn't it?
It's, state.
It is also the responsibility of the union also to say that. Equally, state also should keep in mind that it should be sent immediately.
Otherwise, if there is-
Because if they want to, they can do it in a split of second. Yesterday, we had seen one case. Administrative approval appointment given in a particular date. Same day, appointment order comes. So fast. It seems that it was signed at the same time. So, anyway, yes.
delay from our part because we have received the representation only of 5:10 and was disposed of on 13. And immediately on 13, it was informed to the detainee as well as the state respondents.
Okay, where is the provision which says that you can examine this? Is it section 14 only? Whatever you receive from the state, you can say, you have to say yes, or you have to examine.
We have to examine, Your Lordship.
What is the provision? 14 is revocation. Up till section 12, section 13, it is the state. Then comes 14.
Lordship, if my Lordship will come to section 3.5.
Hmm?
3 clause 5.
3 clause 5.
Very good.
Yes.
When any order is made or approved by the state government under this section, the state government shall within 7 days report the fact to the central government, together with the grounds on which the order has been made and such other particulars as in the opinion of the state government have a bearing to necessity for order, on the necessity for order.
Hmm.
So within 7 days, the state government they have to inform the state government.
This is over and above the representation. Representation may come on its own, isn't it?
Yes, Lord.
But the state government has to inform the central government
Yes,
also.
yes.
But that is regarding information only. Then this is for information without further necessary action. So unless representation comes, central government will not do anything.
Yes, Lord.
They will just receive the copy and say that, okay,
Yes.
this has happened. The presentation comes, then they will examine.
This is just a prior information that person has been presented.
So apart from section 14, there is nothing else.
There is nothing else.
But in the comments section, there's so many things written. If you have the Bear Act, it says it is for the central government to decide whether or not it should revoke the order of the detention in a particular case. In the present case, the detainee was not deprived of the right to making representation. Okay, this refers to some case. Yes, what else, Mr. Yangawati?
That is all, Lordship.
That is all.
Yes. After considering all the documents, the central government have rejected the presentation.
Okay,
That's all.
yes. Mr. Lima, anything else to add?
That's all, but one of the issue raised by the state council, I've submitted beyond my beliefs.
Yes.
Worship, regarding the filing of affidavit.
Hmm.
This is a subsequent event filing to my written. In reply to my affidavit, he filed as well. This issue came up only after I received the affidavit. So it's not necessary to be pleaded in my written petition.
No, this issue came after you filed? After you filed reply?
No, no, no.
What are you saying?
He filed the affidavit in opposition in my written petition.
Okay,
So affidavit in opposition
Hmm.
came subsequent to my written petition.
yes.
So it's not necessarily pleaded in my written petition, filing of affidavit by an officer who is not authorized. So I've taken 3 grounds. In my state council, we see that the 2 grounds, the first 2 grounds, that is beyond the bleedings, that was his submission.
Yes.
So Lordship has submitted the filing of affidavit by an officer who is not authorized. That is an action subsequent to the filing of the writ petition. So that is not required to be pleaded in my affidavit. And regarding the second ground, Lordship, regarding Lordship in the habeas corpus petition, it is a law laid down by the ethics court also, Lordship.
You have not filed reply, no?
No, Lordship, which is not pleaded in the writ petition. That also can be urged in a habeas corpus petition. That is a law laid down by the ethics court. Lordship, I brought only one, I've not submitted a list of books in this case. Lordship, but from the reading of which is reported from GLD, division bench of this honorable court has referred the judgment passed by the ethics court. The 2006 volume 4 GLD 764. Lordship, in para 5, specifically stated.
Read.
And so and so, year 1987, EC 177. The Honorable Supreme Court was of the view that imperfect pleadings in a habeas corpus petition would not stand on the way of granting the relief to which the detainee is entitled to. The Honorable Supreme Court observed that normally writ petitions are decided on the basis of affidavits, and the petitioners cannot be permitted to raise grounds not taken in the petition at the time of hearing. But the said rules, according to the Honorable Supreme Court, cannot be applied to a petition for grant of a writ of habeas corpus. It is enough for the detainee to say that he is under lawful detention. In the burden lies for the detaining authority to satisfy the court that the detention of the detainee was legal and in conformity not only with the mandatory provision of the Act, but also strictly in accordance with the constitutional safeguards embodied in Article 22, Clause 2 of the Constitution. So in the case of habeas corpus petition,
What is the citation?
the Supreme Court citation is year 1987,
AIR 1987
SC
SC
1977,
1977.
Mohi Notin versus TM.
Mohi
Mohi Notin, NUTTI, versus DM.
Tamil Nadu.
See, DM is a provisional
Yes, Tamil Nadu.
state of Tamil Nadu.
What is the
No,
paragraph
no,
number?
no, not Tamil Nadu. D. D for dog.
Oh, DN.
Yes, yes, not Tamil Nadu.
Then what is the paragraph number?
Worship, in this GLD, it's under paragraph 5.
GLT.
Yes, GLD. In the Honorable Supreme Division Bench has referred the judgment passed by the Supreme Court. In this case.
So what is the GLT? Give us
2006,
2006,
volume 4,
2004.
GLD,
Hmm.
764,
It was referred in which paragraph?
paragraph 5.
Mohi, MOHI,
Yes.
Nuti,
Mohi Notin, NUDDI,
NUTTI versus DN.
DM.
Is that all?
Should that's all.
Any other case? Is this case similar? The
Worship,
next case?
the same mistake you have committed in my friend's case. The affidavit filed by the
There are 5 accused persons.
Yes,
This is a co-accused.
yes, co-accused.
So I think it should cover Mr. Lima's argument and the affidavit of the others. Mr. Yangawati, you have not filed the affidavit
I have already filed it today.
today. We permitted you to file it the other day, you came only today. I was looking for it. Anyway. Is it on same lines?
Yes, same, it was actually on the same day, on same deadline.
Lordship.
Would you like to address the court?
Yes, Lordship.
If it's more or less the same thing, I think you can basically
Yes, I
rely
can
upon.
adopt also only 1 2 points I can.
All right,
I agree with this.
sorry.
I agree with this. Just by doing this.
Ah.
So my appearance, my presence is not.
Yes, your appearance is dismissed, but you want your case also to be dismissed? No. We'll pass the order subsequently. We are not reserving it. So we'll think about this and pass the orders. You'll get the orders maybe tomorrow or day after. All right.
May I please, Lordship?
Yes.
Lordship, I was arrested on 11/8/2023. 11/8.
Yes. Your good name, please.
Sharif Ahmed.
Sharif.
Sharif Ahmed. For the accused Thingpam Simra.
You are what? D what?
Sharif Ahmed,
No, no. The accused number.
4.
How was it referred to? A4 or D4?
A4.
A4. Okay.
Thingpam Simra.
Okay.
Lordship, I was arrested on 11/9/2023. While I was going home from town, I was interrupted on the way.
Yes,
I
please.
was intercepted on the way while I was going home by some police personnel, and accordingly, I was taken to the Sovima PS. And thereafter, I was arrested in connection with this case, Lordship. Lordship, I was forwarded before the judicial magistrate on 12/9/2023. At the time of my arrest, the following item was seized from me. Lordship, page number 48, Lordship. Page number 14. Page number 48, Lordship. Annexure F.
Yes.
Page number 48, Annexure F. Lordship can see in the below serial number 10, the things seized from me, 29,450. WB West Bengal number vehicle, Maruti Suzuki Zen, silver color. That's it. This is what seized from my possession. Apart from this, nothing was seized from my possession. Lordship, while I was in judicial custody with effect from 19/9/2023 on 19/8/2023, Lordship, sorry. I was furnished in the jail while I was in judicial custody in jail, Central Jail, Dimapur. On 2/9/2023, I was furnished with a copy of the detention order, grounds of detention, schedule, annexed, and an information. I was not explaining details as to what are these document contains, as I was not well versed in English. I studied only up to class 7, Lordship. Lordship, only on 2/9/23, when my advocate visited the Central Jail, I was explained in details that I have been detained under NSA by order dated 31/8/23. Lordship, I will take you to page number 29, Annexure 1. Lordship, this order passed by the Commissioner of Police and District Magistrate Dimapur on 31/8/23, but my personal copy was not served to me, Lordship. Lordship can see in page number 29, Annexure 1, in below number 7, serial number 7. Copy to OC Sobima PS Dimapur for information. My personal copy was not given to me. Then, Lordship,
When were you arrested?
I was arrested on 11. There is no mention in a detention order also when I was arrested.
11 of what?
11th of August.
It is not given in the order.
No, it is not mentioned in the order.
So from where can we see that you are arrested in 11?
Lordship, I will take you to page number 50, Annexure H, Lordship.
Yes.
This was my first forwarding before the Chief Judicial Magistrate Dimapur. Accused person Thingban Simran, Lanujan and Ponjan are produced before me on being arrested in connection to the aforementioned case.
But date of arrest is not there.
Yes, it is not mentioned, but I was arrested on 11. Lordship, from the seizure memo, it comes out. The seizure memo was done on,
11/7.
yes, Lordship.
This also is wrong. It should be 11/8, isn't it?
So, Lordship, if we see the FIR, it was filed on 10, suo motu FIR,
10th of what? August.
10th of August.
See, come to page 48, an extra.
10th of, Lordship, 10th of July, suo motu FIR.
Oh, 10th of July.
Yes, Lordship. Page number 86.
Hmm.
Here they are talking about 3 persons were arrested.
Yes.
So, Lordship, when I was in judicial custody since 19 of July 2023, I was in judicial custody.
But you said you were arrested on 11/8.
11/7, Lordship.
11/7.
11/7. 11/7, I was arrested, Lordship.
Okay. 11/7.
Yes.
Okay. Then,
So when I was in judicial custody with effect from 19/7/2023, I was furnished in the jail on 2/9/2023, the detention order, along with other documents. So documents which I have annexed in the page number 29 of my writ petition, Annexure 1. What you can see below, copy to serial number 7, OC Kohima PS, Dimapur, for information. My copy should be in serial number 8. I was not furnished that copy as of date. This was the Xerox copy which was done and handed over to me.
you are given on 2nd of
2nd of September 29. While I was handing over this copy, Lordship, I was given only the detention order dated 31/8/23, page 29. Then the grounds for detention, page number 30. Then the approval for detention to the government by the detaining authority, Annexure 3, Lordship. Then the schedule annexed, page 32, Annexure 4, and the information. Apart from these documents, I was not furnished any other documents which the detaining authority has relied upon and passed the detention order. Lordship, I'll take you to page number 30. Page number 30 of my writ petition, Annexure 2. Lordship, it is mentioned here as the grounds of detention. Lordship can come to second paragraph. Now, therefore, in pursuance of section 5 of the said act, the undersigned hereby inform you that the said detention order has been made against you on the following grounds. Now, Lordship, I will take you to the NSA. Section 5, NSA. Section 5 says, power to regulate place and condition of detention. Every person in respect of whom a detention order has been made shall be liable to be detained in such place and under such condition, including the condition as to maintenance, discipline, and punishment for breaches of discipline as such. These are not the grounds, Lordship. It should be either 5A, it should not be 5. This itself says that total non-application of mind, Lordship. Total non-application of mind. Then, Lordship, the approval order which the detaining authority has written to the government, page number 31, Annexure 3. Page number 31, Annexure 3, Lordship. Second paragraph. Third paragraph, Lordship. I'll go to third paragraph straight up. I will come up to first paragraph, but third paragraph. The subject, SS Deputy Cleanser NSNI and Thingpang Simra, 45 years, was arrested for dealing in illegal ammunition and possession of the same. Lordship, the
No,
seizure memo is very clear.
you're reading from page 30,
Page 31, Lordship.
31.
That is the letter of approval sent to
Yes.
the government for approval. Second paragraph. The subject, SS Deputy Cleanser NSNIM, Thingpang Simra, 45, was arrested in dealing in illegal ammunitions and possession of the same, which is totally false, Lordship. My seizure memo is very clear, Lordship. When I was arrested on 11, I am from my possession. Now, no arms and ammunition were seized. no arms and ammunition. From my possession only 29,550 rupees, 950 or 550, and one West Bengal number Maruti Zenka. That's it.
That
Those-
was, that was in page. Caesar memo.
Page number 48, Lordship.
48.
11/7/23. Then below, Lordship can see in serial number 10, page number 48, annexure F.
Yes.
So these are the items seized from me. Serial number 10. Rupees 29,450. WB-02V22232 Maruti Suzuki Zen silver color. Only these are the two items which you seized from me. Apart from these two items, nothing has been seized from me. On 11/7/2022, nothing has been seized. Lordship, I'll take you to page number 58. Page number 58.
No.
Annexure.
Just a minute.
Yes.
Pingbam Shimra.
Yes, Lordship.
Okay.
My name,
So,
my name appears in serial number 5 of page number 48. That is property search and seizure form. Pingbam Shimra. I was arrested. It is mentioned here 11/7. Date of seizure 6 p.m. 1800 hours. I was arrested at 6 p.m. Now, Lordship, I'll take you to page number 58. This is the seizure. Page number 58, annexure M. This is the seizure memo from whom these items were seized, but not from me. Serial number 5, Lordship. Serial number 5, Rosun Pomai, Mapui. From him, this item was seized.
so they mixed up,
Yes.
saying that it was seized from you.
Yeah. So this is a false statement they have given in the grounds of detention, Lordship. So here, Lordship,
This approval is given by the state government.
yes.
Okay.
So in the approval, they have written page number 31, Lordship, again. Page number 31.
Yes, yes.
Second paragraph. As per records made available by the sponsoring authority.
Hmm.
Your Lordship, I was not furnished the report of the sponsoring authority. When I was furnished with a copy of this detention order and other documents, only 5 documents I have given. So thereafter, Lordship, I have submitted my representation.
Where?
Page number 35.
35.
Page number 35.
Hmm.
In my representation, the date was nil, but the jail authorities, they have received and they have given a receipt. I have Xerox there. This is the original. This is the original receipt.
11/9.
It is here, Lordship, you can see.
Ah.
This is the receipt the jail authority has given, that on 11/9/2023, I have submitted a representation.
Receipt number 594.
Receipt number 594, correct.
Okay.
Lordship, my representation I have addressed to number 1, the Secretary, Ministry of Home Affairs,
Hmm.
Central Government. Number 2, Chief Secretary, Nagaland, Special Secretary, Home Department, Political Branch, Nagaland, Principal Secretary, then Chairman Advisory Board, the Commissioner of Police and District Magistrate. I have submitted my representation explaining in details that my detention order be revoked. I was not furnished with the full set of the documents also. Nothing had been accepted. Lordship, on 11/9/2023, when I went to the jail for submitting this representation, there was no approval letter received by the jail authority. On 15/9/2023, the jail in the jail itself, I was served the approval order passed by the central government, state government also. In my representation also, I have stated that my personal copy was not served and I was not submitted. I was not furnished the full set of the documents. Then on 15/9/2023, page number 61, Lordship, Annexure 7. I was furnished the approval order passed by the government of Nagaland, and I have received on 15/9/2023, which was passed on 11/9/2023. I have received on 15/9/2023. The order was passed on 11/9, page number 61, Lordship, Annexure 7. Annexure 7, dated 11 September 2023.
What is this?
This is the approval order passed by the government of Nagaland. So here, Your Lordship, I have received this approval order only on 15/9/23. This point to be noted, Lordship. It is mentioned here. I will go to the last paragraph, Lordship. Now, therefore, in exercise of powers conferred by Section 3(2) of the said Act, the state of government of Nagaland hereby orders Mr. Thingbam Simra, SS Deputy Colonel NSNIN, be detained and kept in Central Jail, Dimapur, for an initial period of 3 months, with effect from the date of detention till 30/11/2023, and within which period the detention will be reviewed as required. So here the important point I wanted to point out is my detention order. From the date of detention, I have to be detained till 30/11/23. That is for 3 months. They have mentioned 3 months. Lordship, I will draw your attention. 3 months, 31st August, that is 1 day. Then comes September 30, October 31, then November 30. This altogether becomes 91 days. But I was detained for 92 days. From 31, from the date, with effect from the date of detention till 30/11, it becomes 92 days. Whereas if we count in figure, it should be 91 days and 3 months. When it is 3 months, it should be 91 days. But I was detained for more than 3 months. That is 92 days. This is also I wanted to just point out. So, Lordship, when I was furnished this document, along with this document, I was furnished the approval order which I already received on 2/9/23, the order of detention, the grounds of detention, the schedule, and the document which I have not received on 2/9 are page number 68. Page number 68 of my writ petition. Page number 68, Annexure 13. These are the documents I have not received. These are the documents till page number 103. I was not furnished while handing over the detention order to me on 2/9/23. Page number 68 to 104. Annexure 13 and 14. 103, Lordship, 103. Annexure 13, collectively I have made it. Annexure 13, page 68 till 103.
These documents,
These documents I was not furnished at the time of handing over the detention order on 2/9/23 while I was in judicial custody in Central Jail, Dimapur. What is here? This is in total violation of Article 22, Clause 5. I'll draw your attention in Article 22, Clause 5, Lordship. Article 22, Clause 5. Article 22, Clause 5. Lordship, before I read Article 22, I will read Article 4 also.
see, Mr. Counsel,
Lordship.
I think we're really out of time today. Can we continue this tomorrow?
Sure, I say come from Dimapur.
No, there's a single bench we have in the afternoon. We would like to take up that single benches, since we have some part-hard matters also in that.
I'll not take much time, Lordship. Afternoon, I'll take little time only. Otherwise, the authority is already submitted my run finish all that. I'll give one to authority. Little seconds.
See, if you submit, the other side will have to submit also. How long will you take? Oh. When can you come?
Next week, Lordship.
Next week?
Yes, Lord. Has to come from all the way because I'm at every question. So,
Next week, this bench is not available. So you can take it up next week afresh if you want to. Meantime, the other matter has to be disposed of. You might have that might cover your case also in a sense.
yes, yes, Lordship.
Because without hearing you, we would like to give a chance also, but
Yes.
time is short, that is the thing.
And tomorrow I'll come. I'll manage to come.
Tomorrow.
Yes.
Okay. This is the matter again as part tomorrow. But try to make it precise and concise.
Lordship.
Because tomorrow also we have some few matters which is lined up.
The
Okay.
main point I've already submitted.
Okay. What did I say? As part.
No, no, yeah, yes, yes. I'm
Sorry. For judgment, item number 50.
May I please, Lord?
The writ petition is dismissed. Interim order passed earlier shall stand merged with this order.
For judgment, item number 51.
Yes, the writ petition also dismissed.
May I please, Your Lordship?
Yes.
Lordship, I have a prayer. And there is a part heard matter which is listed in the supplementary list item 53, Your Lordship. But there are other fixed admission hearing matters, but I pray that the part heard matter that may be taken up first. My prayer, Your Lordship. The part
Okay.
heard yesterday one. Supplementary 53.
Okay, we'll take it first.
Lo-
If there's anyone to mention matters, you can mention.
May I please, Your Lordship? Lordship, I beg to mention item number 42.
42. Yes,
Lordship, who would like to file additional affidavit? Kindly grant us 3 weeks' time to file additional affidavit.
petitioner. Okay, as paid for by learned counsel for petitioner. Further, 3 weeks time is granted for filing additional affidavit.
Lordship,
This
there is an interim order.
interim order passed earlier to continue till the next date. Yes,
Lordship, item 12, this parties are ready for hearing, but it will not be, this is a fixed item for
Yes.
admission.
Mm.
So may I pray that this may be listed after tomorrow? Thursday. It's a short matter, Lordship. Thursday.
Thursday, I don't know.
We can make an attempt, Lordship. I'll take, it's a very short matter.
Okay, subject to time, all right. I
Lordship.
cannot give you any. Okay, 12 as paid for is the matter again on Thursday. Give the date,
Day after tomorrow, that is 15.
15, yes.
15.
All right,
Please, Your Lordship.
Yes.
Lordship, I beg to mention item 36, Your Lordship. State may be granted a further time of 3 weeks to file affidavit, Your Lordship.
how much time?
3 weeks' time, Your
Okay,
Lordship.
3 weeks time is granted to the state for filing affidavit, counter affidavit, as paid for.
May I please, my lord.
Hmm.
My lord, I may be allowed to mention for item number 8, lordship. I'm yet to file my affidavit in reply, lordship. A week's time may be granted, lordship.
Okay, a week's time is granted to the petitioner for filing the joint affidavit.
Lordship, I may be also allowed to mention for item number 38. Lordship, hearing item number 38. Lordship, I've received an additional affidavit filed by the petitioner, lordship.
38,
38, lordship.
okay.
2 weeks' time may be granted, lordship.
Additional affidavit by
Yes,
whom?
the state, the
The
petitioner has
petitioner,
filed
I'm the petitioner.
additional affidavit
You
as
are
per the
for?
direction of this court, lordship.
You are for?
I'm for the respondent number 4, lordship.
Although the matter is listed for hearing,
Yes, lordship.
but in view of the affidavit filed by the state respondents,
The
by the petitioner,
Petitioner, lordship.
additional affidavit filed by the petitioner, the counsel for the respondent number 4,
4, lordship.
placed for 2 weeks' time
Yes, lordship.
to examine the same and file a response. Whereas allowed, list the matter again after 2 weeks.
Perhaps Lordship, if Lordship may be gracious enough to fix the matter on 1st of April, because Lordship, in the month of March, my senior has some appointment, medical appointment. So if Lordship may be gracious.
What do you
enough
say?
to-
Lordship, if it is a medical emergency, lordship, I have no objection.
Okay, what did I say last line? List the matter again. Instead of that, you write 1st of March.
1st of March, Lordship.
Okay. 1st of March, 2020.
1st April, Lordship.
Oh, 1st of April.
1st April,
All right.
April. My apologies. Lordship is an interim. Interim to continue.
You indicate that as prayed for, as prayed for, list the matter again on 1st of April, 2024. Interim order passed earlier shall continue till the next date.
Highly obliged, Lordship.
Lordship, I beg your pardon, in item number 8, there is also an interim, lordship.
Item 8, you
Yes,
also include
I've
interim
already
order
mentioned
passed
also.
earlier shall continue till the next date. Item
Obliged.
8.
May I please, madam?
Hmm.
Lordship, I beg to mention item number 11.
Yes.
3 weeks' time may kindly be granted to file counter affidavit, your lordship.
Okay, 3 weeks' time is granted to the state respondents for filing counter affidavit.
Mr. Lordship, I'm for respondent number 9. I may be allowed 3 weeks' time to file my counter, Your Lordship.
Similarly, respondent number 9 is also granted time of 3 weeks' time for filing counter. Okay.
Obliged, ma'am.
Lordship, I have a similar prayer for item number 37.
Yes.
Here, your lordship, I'm praying for my friend KV. And I'm told that he is yet to receive instruction, your lordship, in this matter. If 3 weeks' time can kindly be granted, my lord.
There's no name in the cost list
Lordship,
for the
yes.
petitioner.
I'm for the petitioner, your lordship.
There's no name shown.
My name may be reflected in the post list, your lordship.
Okay, 3 weeks' time is granted to the state respondents for filing counter affidavit as paid for. Name of the petitioner, name of the counsel for the petitioner be reflected in the cost
Lordship,
list.
interim order may be continued until the next future.
Okay. Name of the counsel for the petitioner be reflected in the cost list hereafter. To stop, the interim order passed earlier shall continue to the next date.
Deeply obliged, my lord.
May I please, Your Lordship.
Hmm.
May I be pleased to mention item number 7, Your Lordship.
Yes, what do you want?
3 weeks may be granted for filing counter.
Okay, 3 weeks time is granted to the state respondents for filing counter affidavit as paid for.
Chief, there's an interim.
Interim order passed earlier shall continue to the next date.
Your Lordship, I also beg to mention item number 18 to 34, Your Lordship. Your Lordship, another 3 weeks may be granted, Your Lordship. Here, I'm assisting additional AG, Ma'am Shakri, Your Lordship.
What are these matters?
Your lordship, the matter petitioner is praying for minimum skill pay, your lordship.
Okay,
And if my lord may kindly see the order dated 1910 passed by this honorable court.
what was that?
3 weeks' time is given.
Okay,
And further observation has been made by this court that endeavor shall be made by the respondent to file affidavit before 3 weeks, your lordship.
Right.
Now, we are 16th week is running, your lordship. That was passed in October. So, your lordship, of course, they need to file affidavit, but let it be for the last chance, your lordship.
Lordship, an opportunity will be given.
Yes, it's okay, but as last chance, your lordship.
Your Lordship, here I'm assisting additional AG, Your Lordship. So,
Miss Livika Lanet, State Council submits that further 3 weeks time may be granted for filing counter affidavit. Stop Mr. T.B. Jamil, Lanet Council for the petitioners submits that sufficient opportunities have been granted And if time is to be granted, let it be as a last chance. To stop considering the fact that the matter is of the year 2023. One more opportunity is granted to the respondents for filing counter affidavit. List the matter again after 3 weeks.
Your Lordship, I also beg to mention item number 5 on behalf of Bichano. Item number 5.
5.
Yes, Your Lordship. She's yet to receive instruction. Your
Okay,
Lordship.
as paid for.
3
Further
weeks,
3
Your
weeks time is granted to the state respondents for filing counter affidavit.
Your Lordship, item 16 on her behalf. Bichani, item 16 and 17 on her behalf. Your Lordship.
16 and 17 also. Okay.
Yes, Lordship. Much obliged.
May I please, Lordship? Item number 15, waiting for instruction.
Just a minute. Item 17, just show me the file. This is for orders, so there must be something. 17. Who is appearing for the petitioner? 17.
Yes, Lordship.
What to do? The notice has not been served to respondent number 4.
No, we have already served notice. It's still away.
You have taken steps, but notice has not been served. Because there is no report. That was last year. Why don't you take fresh steps? Respondent number 4. This is the additional deputy commissioner and administrative Mokchung Municipal Council. Is there any post as such? Additional DC and administrator. Mokchung Municipal Council.
Yes, Lordship.
There is.
Yes.
Can you serve by Dusty? Okay, please write neither unserved. No, cancel that. You write like this. Office note indicates that neither AD card nor unserved notice has returned back from respondent number 4. To stop. The petitioner is allowed to serve notice upon respondent number 4 by way of Dusty within a period of 2 weeks from today. To stop, an affidavit shall be filed thereafter. As proof of service, list the matter again after 3 weeks. State respondents to file their counter affidavit in the meantime. Okay. 17. Yes, any more
Please,
mention?
Lordship. Item number 15, I'm yet to receive instruction, so kindly grant 3 weeks of time.
You are for respondents?
Yes, Lordship.
Okay, as paid for by the Learned Council for the state respondents. Further 3 weeks time is granted for filing counter affidavit.
I'm preparing for respondent number 3 and 4. I'm also yet to file my counter 3 weeks time and we'll get it.
It's okay, you file. It'll cover your case also. Yes.
Lordship, similarly, item number 35, behalf of Tipapong, yet to receive info.
And for the petitioner, there's an interim here.
Okay, as paid for by the state respondents. Further 3 weeks time is granted for filing counter affidavit. To stop, the interim order passed shall continue to the next date. All right. Yes. 14, 1-4. Okay, how much time? As paid for by Mr. Gauhati, Lanet CGC, appearing for the respondent Union of India. Further 3 weeks time is granted for filing counter affidavit.
So, Lordship.
Yes.
Your Lordship, I beg to mention item number 13.
Yes.
The state is yet to file affidavit, so kindly grant me 3 weeks time.
Okay, as paid for by the state
No.
respondents.
Moreover, Your Lordship, this is analogous with WPC number.
Just a minute. As paid for by the state respondents, further 3 weeks time is granted for filing counter affidavit. List the matter again after 3 weeks along with
WPC 271 of 2023.
WPC 271 of 2023. All right.
Your Lordship, hearing item number 40. Kindly let the matter come up after 1 week.
40.
Yes, 40.
Okay, as paid for by the London State Council. List the matter again after a week.
May I please, Your Lordship?
Hmm.
Lordship, here I'm the petitioner. Lordship, if this matter can come up on 20. That is next Thursday, Lordship.
Is it okay? So you just add that after a week on 20th of February 20.
May I please, Lordship? Lordship, I beg to mention here in item 45 to 49.
Hmm.
It's analogous matter, Lordship.
Hmm.
Lordship, here my senior age is in bereavement. So Lordship, I pray may your grace, Lordship be gracious if this matter can come up on 26.
Any
Your
objection?
Lordship, make it on 27.
Mr. Azo, learned counsel for the petitioners, is said to be in bereavement. Stop on a prayer made on his behalf and unobjected to by the other side. List the matter again on
Lordship, 29.
29th of February 2024.
May I please, Lordship, again. Lordship, I beg to mention item 4.
Yes.
Lordship,
Oh, same day.
same Lordship. 3 weeks time may be granted, Lordship.
What?
Lordship, for admission hearing.
No, you don't want it on that day. You don't want it on 29.
Lordship, no. Lordship.
Okay. Item 4, you write a separate order. Mr. Azo, learned counsel for the petitioners, is reported to be in bereavement. Stop on a prayer made on his behalf and not objected to by the other side. List the matter again after 3 weeks for admission.
Much obliged.
Yes.
Motion by like to mention item 6.
6, yes.
I mean, we allowed 3 weeks time for the contest to come.
Okay, on the prayer of Mr. Moemchen, London State Council, further 3 weeks time is granted for filing counter affidavit. Yes.
May it please your lordship. My lord, may kindly allow me to make a mention for an unlisted matter which may kindly be listed on Thursday, arbitration petition number 1 of 2024.
Oh, that was listed the other day.
Yes, lordship,
What
but the
happened?
coast list came out after we reached the court and we did not know that the matter would be listed. So my lord, may kindly allow this matter to be listed on Thursday.
Arbitration is to be taken up by any particular bench or it's open?
Lordship, it is addressed to the Chief Justice. So lordship, I believe any bench. can
No,
take up.
why I'm saying is because every bench has got some kind of allotment that so and so will handle all the arbitration matters.
As far as Kohima is concerned, in fact, my learned senior, the president is also here.
You have a thing, the mention memo.
Yes, lordship.
Okay. You just find out.
My lord.
Okay, Thursday, we'll see.
Thursday, my lord.
You also try to find out.
My lord, I
If
will.
there's something, we should abide by that. If there's nothing, there's no issue. We'll do it.
Lordship.
Okay.
Oblige, your lordship.
Lordship, I'd like to mention item number 10.
Yes.
Lordship, if this matter can come up next Thursday.
Okay. You're for the other side.
I will go to applicant with the IA.
Any objection?
Since other council has also filed a leave of absence.
As paid for by the London State Council. List the matter again on Thursday next. 22nd, is it? Yes.
May I please, Lordship?
Yes.
Lordship, I beg to mention hearing item number 39 on behalf of my senior, Jamir. Lordship, my senior is having some difficulties, personal difficulties today. Lordship, I pray that the matter may come after a week. Item 39.
Okay. As paid for. List the matter again after a week.
Lordship, item 9, I'm here to file my reply. 3 weeks time may be granted.
As paid for, 3 weeks' time is granted to the petitioner to file a rejoinder affidavit.
Deeply obliged.
Yes, Your Lordship.
Hmm.
Your Lordship, kindly allow me to mention item number 41.
Yes,
Hearing item, Your Lordship, it may be listed after 3 weeks.
you are for the petitioner,
Yes, Your Lordship.
as paid for by the learned counsel for the petitioner. This is the matter again after 3 weeks.
And Your Lordship, I have a similar prayer for item number 44.
Similar order, item 40.
Bless you, Lordship.
Please, Your Lordship. Your Lordship, item number 37. Your Lordship, this item has already been mentioned, Your Honor. Your Lordship, I have failed to make one submission. Your Lordship, I may be allowed to reissue notice to respond number 5 and 6 through Dusty Service, Your Lordship. I'm for the petitioner, Your Lordship.
Please write down. Since notice has not been served upon the respondent numbers 3 to 6,
Your Lordship, 5 and 6, Your Lordship.
it says 3 to 6.
5 and 6, Your Lordship.
Three to 6.
Okay, Your Lordship.
Petitioner is permitted to serve notice upon them by way of Dusty within a period of 2 weeks
Yes, Your Lordship.
from today through the registry of the school. Instruct the petitioner shall thereafter file an affidavit indicating thereafter file an affidavit as proof of service. Show proof of service. This is the matter again
3 weeks.
after 2 weeks.
Much obliged.
Please reconcile that order, okay? What about this item 1, 2, and 3? Nobody's mentioning.
Lordship, Lordship here, I'm led by my senior Mr. P, SSD.
When do you want it?
Lordship on 26th.
As paid for by on behalf of Mr. S.S. Day, Learned
26
Senior
February.
Counsel for the petitioners. This is the matter again on
26th February.
26 February 2024.
Lordship. Thank you, Lordship.
So the coast is clear for you, Mr. T.P. Jain.
There is another matter, item 52, Lordship. If time permits, we can make an attempt.
All right,
If time permits, we can make an attempt.
all right, all right. It's a short matter.
Subject to my, yes.
No, I will take half an hour, only 30 minutes at most.
For hearing, item number 53.
The other side has not started, isn't it?
Yes.
Mr. Younger, what is yet
Younger
to
one.
start?
Your Lordship,
You had,
3 grounds I have submitted on.
out
three-
of 6 grounds, you have cleared 3 grounds.
3 grounds. I
Three-
believe,
three
3
remains.
grounds. And yes, and as regards the presenting officer, Your Lordship, non-appointment of presenting officer, yesterday I have submitted the list of books. I'll take Your Lordship to one decision, Your Lordship, on presenting officer, 2023, 6 GLT, 730. Yesterday I have submitted the list.
2023,
Volume 6, GLT 730. This is just
Paragraph.
paragraph, Your Lordship. 5, 6, within bracket Roman 3, 7, 8, 9, 10, and 14. These are short paragraphs.
Yes.
This passed by the Honorable High Court, for Your Lordship. Para 6, Lordship has got it. May I read out?
Yes.
The learned counsel for the petitioner raised only one ground in assailing the impugned order. It has been submitted by Mr. Such and Such, learned counsel appearing for the petitioner that the departmental inquiry of the petition was conducted without appointing a presiding officer. That was the only ground. And the inquiry officer himself acted as a presiding officer and conducted the examination in chief of the prosecution. Now, witnesses and led them through the facts so as to present the case of the disciplinary authority against the petitioner, and that the inquiry officer acted as a judge and the prosecutor in the said inquiry. It has also been vehemently submitted by the legal counsel for the petitioner that such act of the inquiry officer has greatly prejudiced the petitioner's right to a fair inquiry, and that a reasonable opportunity of being heard has also not been deprived, of. The learned counsel further submitted that non-appointment of presiding officer vitiates the full departmental inquiry, and accordingly the impugned orders are unsustainable in the eye of law and are liable to be quashed and set aside, and the respondents be directed to reinstate the petitioner in service and to hold a fresh inquiry by appointing a presiding officer and by following the principle of natural justice, and to complete the said inquiry within the stipulated period.
This is regarding your point number 2.
Yes, point on presiding officer, this judgment I have not realized, so I
Non-appointment of
presiding
presiding officer.
Lordship. Now, para 6. The learned counsel for the petitioner submitted that even if there is no provision under the CIPF rules 1955 for appointing a presiding officer to conduct the departmental inquiry on behalf of the disciplinary authority, the conduct and action of the inquiry officer in the departmental inquiry against the petitioner by assuming the role of a judge and prosecutor greatly prejudice the rights of the petitioner to have a fair trial, and accordingly vitiates the departmental inquiry held against the petitioner. Now, may I take your lordship to the other cases are reported. 1 para 3, Roman para 3, your lordship, in small. Judgment and order dated, your lordship has got it.
Page
will be in the next page. In para 7, number 1, in support of this contention that is quoted, and para 2, judgment order dated passed by division bench is also there. Your lordship has got it in Roman, small.
How does it start? Paragraph 3.
Judgment and order dated 1/2/2019.
Yes, got it.
Yes. Judgment order dated 1/2/2019 passed by division bench of the Honorable Gauhati High Court in read appeal number such and such. The question that arose for consideration before the learned single judge, among other, was with regard to the inquiry being vitiated for want of appointing of the presiding officer in the inquiry proceeding. The contention in that regard was that with regard to Rule 27 of the CRPF Rules 1955, which lays down the procedure for conducting disciplinary proceeding. The appellant here have contended that the said rule does not contemplate appointment of a presiding officer, and therefore the inquiry is not vitiated if the presiding officer is not appointed. The learned single judge was, however, of the opinion that non-appointment of presiding officer would vitiate the proceeding, and it is in that view the learned single judge was of opinion that the order dated such and such, thus pursuant to such defective inquiry could not be sustained, and also the dismissal of the appeal by the appellate authority through the order dated such and such is not sustainable. 4. The instant appeal is filed claiming to be aggrieved by such order passed by the learned single judge. The contention in the instant appeal is also with regard to the very same issue wherein the appellant contend that non-appointment of presiding officer is not contrary to the procedure laid down under Rule 27 of the CRPF Rules 1955, and therefore it is contended that the learned single judge was not justified. Though such contention is urged in the instant appeal, the position at present is that the very issue was pending before the Honorable Supreme Court, where the appellants here, being the appellant in the said proceeding, had raised the very contention relating to the provision as contained in Rule 27 of CRPF Rules 1955.
The Honorable Supreme Court, while dealing with the issue in the case of such and such, has clarified that non-appointment of presiding officer would vitiate the inquiry proceeding, and therefore consequential order passed by the dismissal would not be sustainable. If that be the position, when the position of law has been settled by the Honorable Supreme Court, the same would also apply to the present case as well. If that be the position, we see no error committed by the learned single judge, so as to call for indifference in that appeal. Accordingly, the instant appeal being devoid of merit stands disposed of. This is an appeal filed by the Union, Your Lordship. Next, para 7. Mr. Bobby Potsambam, learned CGSE, appearing for the respondent, submitted that the departmental inquiry was conducted as per rules and laid down procedure, and that during the course of inquiry, the petitioner pleaded guilty to the charge framed against him. It has also been submitted that petitioner was given all opportunity to defend his case by the inquiry officer at every stage of the inquiry proceeding, and accordingly, there is no question of violation of principle of natural justice, and no prejudice has been caused to the petitioner during the whole departmental inquiry, and that the charge framed against the petitioner had been proved in the inquiry proceeding, and on that basis, on the basis of the inquiry report, the petitioner was awarded the punishment of removal from service. So far as non-appointment of presiding officer is concerned, the respondent have not denied the fact that no presiding officer was appointed in the said departmental inquiry. Mr. Bobby Potsambam, the learned CGSE, placed before this court a circular dated, this is the circular issued by them, issued by the Director General of CRPF, containing order with regards to appointment of presiding officer and defense assistant in the departmental inquiry against a member of the force, their own notification, under CRPF Act 1949 and CRPF Rules 1955, which inter alia provides as under. At the time of appointment of inquiry officer, the disciplinary authority shall also issue an order, appointing any member of the police of the force below the rank of assistant commandant posted in the same unit or establishment as presiding officer to present the case on behalf of the disciplinary authority in support of the article of charge in the departmental inquiry with information to the inquiry officer. After the evidence on behalf of the prosecution and defense is completed, the EO shall hear the PO or permit him her to submit written brief within a period not exceeding 10 days. Inquiry officer EO will thereafter forward copy of the same to the CO for submitting his defense brief, if any, within a period not exceeding 10 days. Mr. Bobby Potsambam also submitted.
Mr. Jamir, yesterday you were reading that CRPF rules.
Yes.
Does not provide anywhere, isn't it?
Under 27, there is no provision.
So how come this provision has now come?
This is a notification.
This is quoted from CRPF rules.
Under the CRPF rules, Your Lordship, Rule 27, there is no provision for appointment of presiding officer, but Rule 102 says that CCS rules will apply.
No, but this one, I'm talking about the present one, which you just read.
The notification?
Yes.
This is a circular issued by them, Your Lordship.
Oh, this is a circular.
Circular, Your Lordship. Because circular, if rule is silent, circular can supplement, Your Lordship.
Okay, anyway, the circular was relied upon, so presenting officer a must. And the finding of the learned judge here is that it's vitiated.
Yes.
Set aside.
Yes.
And then liberty was granted to initiate fresh proceeding.
Afresh. Yes.
And you'll be treated as being suspended.
Lordship.
Since it's only on technical grounds.
Yes, Lordship.
So if no further inquiry is contemplated, then within a prescribed time, he shall be reinstated with all consequential benefits. So that is the thing. So basic sum and substance is that appointing of the presenting officer is a must.
Is a must.
And without that, the entire proceeding is vitiated.
Vitiated.
Okay.
And my submission is that if there is a rule which provides for doing a thing in a particular manner, it must be done in that manner or not at all, Your Lordship. It is immaterial whether any prejudice is caused or not.
Okay.
Now,
what else?
Coming to my foreground, Your Lordship, my submission is that framing of charge under 11.1 is not legally sustainable, and therefore, Your Lordship, imposing punishment of removal under section 11.1 also does not have legs to stand, Your Lordship. That is, On fourth round, that is my only submission, Your Lordship. So the order of removal is liable to be quashing set aside. When charge under section 11(1) cannot be framed against me, I cannot be imposed punishment under that.
Okay.
So it has no legs to stand.
And next,
Next, Your Lordship, on proportion, whether the penalty imposed is proportionate, Your Lordship. Now, even assuming, Your Lordship, that imposing of punishment, holding inquiry, framing article of charge under 11(1) and imposing punishment under section 11(1) is what? Valid, Your Lordship. Even then, Your Lordship, the punishment of removal from service that has been imposed to the petitioner is not proportionate to the offense for which he has been charged, Your Lordship. Now, as already submitted, Your Lordship, yes, petitioner, he has overstayed in service period. That is admitted. But then, whether it was intentional or not, Your Lordship, whether it was intentional or but due to facts and circumstances which were beyond the control of the petitioner, Your Lordship. Now, admittedly, in support of his defense, he could not place any documents before the inquiry officer, the death certificate, Your Lordship. That is there, Your Lordship. But for a charge of to say that overstay in service amounts to misconduct, Your Lordship, the disciplinary authority has to first satisfy that that was willful. Unless the absence is willful, overstaying leave is willful, intentional, Your Lordship, that will not come within the term misconduct, Your Lordship. Now, what will constitute sufficient time?
sufficient time.
What will constitute sufficient time for the petitioner to produce the documents in material in support, Your Lordship? In this case, petitioner was given 15 days time, Your Lordship. But that will depend on the facts and circumstances of the case, Your Lordship. As stated, Your Lordship, his deceased brother at the time of his death, he was serving the forest department, and upon his death, all the death certificate along with other service records were submitted to the department to pursue his retired terminal benefit, Your Lordship. And because of that, Your Lordship, he could not produce any documents in support, Your Lordship. But he has annexed the death certificate, Your Lordship, in his appeal memo. Now, in my respectful submission, Your Lordship, in fact, the rejection of appeal and this will come together, Your Lordship, in a way. My submission will cover both. The appellate authority ought to have considered that aspect of the matter and just to examine whether his absence overstay in service was willful or not, Your Lordship. Now, unless the absence is willful, Your Lordship, it will not amount to misconduct as held by the Honorable Apex Court, Your Lordship. And for that, Your Lordship, I may be allowed to refer to one authority. Unless absence is willful, it will not amount to misconduct. That is in 2012, Your Lordship, Volume 3 SCC 178.
2012.
2012, Volume 3 SCC 178.
Paragraph?
Para, Your Lordship, 17, 18, 19, 24, and 25. Lordship has got it. Oh, sorry, 17, 18, 19, 24, and 25. These are short paragraphs, Your Lordship. May I read out?
Yes.
If the absence is the result of compelling circumstances, under which it was not possible to report or perform duty, such absence cannot be held to be willful. Absence from duty without any application or prior permission may amount to unauthorized absence, but it does not always mean willful. There may be different eventualities due to which an employee may abstain from duty, including compelling circumstances beyond his control, as accident, hospitalization, etc. But in such case, the employee cannot be held guilty of failure of devotion to duty or behavior unbecoming of a government servant. In the departmental proceeding, if allegation of unauthorized absence from duty is made, the disciplinary authority is required to prove that the absence is willful. In the absence of such finding, the absence will not amount to misconduct. In the present case, the inquiry officer on appreciation of evidence, though held that the appellant was unauthorisedly absent from duty, but failed to hold that the absence was willful, the disciplinary authority, as also the appellate authority, failed to appreciate the same and wrongly held the appellant guilty, Your Worship. Here I am mostly stressing on the appellate authority, Your Worship. Now 24, Your Worship. In the result, the appeal is allowed. The interim order of dismissal passed by the disciplinary authority, affirmed by the appellate authority, the Central Administrative Tribunal and the High Court are set aside. The appellant stands reinstated. Take into consideration the fact that the charge officer has suffered a lot since proceeding such and such and such. Those back wages, I am not claiming that, Your Worship. Now, may I take Your Worship to another case law, Your Worship? 1994.
Just a minute. It says illness, accident, hospitalization.
Yes, etc., etc. This is not exhaustive. Etc. is given. Your
No,
Worship.
what happened in this case? What was the reason?
In this case, Your Worship, I've just read out the. In fact, yeah, it was, if I'm not mistaken, there was he was a medical case, Your Worship, a mental problem. Para 3, Your Worship. This is where, like, he was prevented, though he reported he was prevented from signing attendance register. But however, Your Lordship, the principle we has been laid down, unless the absence is willful, Your Lordship, such absence may amount to unauthorized absence, but not being willful, it will not amount to misconduct. Unauthorized absence, or not all unauthorized absence will amount to willful, amount to misconduct, unless such absence is willful, Your Lordship.
Petitioner was absent for 181 days.
Lordship.
181 days.
181 days, Your Lordship.
Did he send any message, any phone call, anything like that?
No.
Or
that,
he was
no, that I am not aware.
Or he was somewhere in a place where he's unreachable.
respect postal system here in this part of the country, part of the state, your lordship, that is difficult.
Okay, next.
Now, next authority, your lordship, is 1994, Supply 3 SEC 755.
1994 supply.
Volume 3 SEC 755.
Hmm.
Para 2.
Hmm.
Twelfth line from top, your lordship. You will just read out the relevant question. The
Yes.
incumbent, while admitting the fact that he had overstayed the period of leave, lordship has got it. Just about para after para page line 12th line. The incumbent, while admitting the fact that he had overstayed the period of leave, had explained the circumstances in which it was inevitable for him to continue on leave as he was forced to do so on account of unexpected circumstances. We are of the opinion that the punishment of dismissal for overstaying the period of, here it is only 12 days, but I'm not on the number of days. In the said circumstances which have not been controverted in the country is harsh, since the circumstances shows that it was not his intention to willfully float the order, but the circumstances forced him to do so. This is just like the absence is not willful, your lordship. So unless the absence, unauthorized absence is willful, it will not amount to misconduct, your lordship. Now, so in my respectful submission, your lordship, in the case of the petitioner, his absence overstaying of leave for 181 days, your lordship, it was not willful, but due to circumstances beyond his control. So, your lordship, so the such absence, overstaying of leave cannot be termed as misconduct, your lordship, and so as to impose the punishment, the punishment of removal from service, your lordship. Now, last, your lordship, on non-application of mind by the appellate authority. Now, as I'm at the cost of repetition, your lordship. Now, my respectful submission, in fact, as held by the Honorable Appellate Court authority, I'll be placing before your lordship. The appellate authority cannot simply adopt the language employed by the discipline authority and uphold the order passed by the discipline authority, your lordship. He has to form his own opinion, and he should apply his mind, judicious mind, your lordship, with reference to the material available on record, your lordship. To support my submission, your lordship, I just rely on one authority, 2006, volume 11 SEC, 147, para 9 and 11. This will be my last submission. Para 9 and 11. May I read out 9? We have also perused the order passed by the general manager such and such, which is available at such and such, and order passed by the director, who is the appellate authority. A close scrutiny of both the orders would only go to show that the appellate authority has simply adopted the language employed by the discipline authority and inflicted the punishment of dismissal on the present respondent herein. Para 11, your lordship. A perusal of the order passed by the appellate authority would only reveal the total non-application of mind by the appellate authority, your lordship. We therefore have no other option except to set aside the order passed by the discipline authority and the appellate authority. Now, why I'm saying that there was no application of mind by the appellate authority, your lordship, is
In spite of the fact that the petitioner here he has annexed the death certificate of his deceased brother, and which was his defense for overstaying leave, Your Lordship. That aspect of the matter was not taken into consideration by the appellate, but simply rejected the appeal filed by the petitioner on the ground that there is no new facts or no new materials for him to review the order passed by the disciplinary authority, Your Lordship. So in my respectful submission, that even the order passed by the appellate authority, Your Lordship, is not legally sustainable, Your Lordship. So just to sum up, Your Lordship, like framing of charge under section 11(1) of the CRPF Act 1949 is bad in law. It's one. Second is, Your Lordship, non-appointment of presiding officer, which is the entire disciplinary proceeding. Thirdly, Your Lordship, taking into account the past conduct of the petitioner, which was not part of the article of charges framed against him, in proving the charge against the petitioner, Your Lordship, that is also not not legally sustainable, Your Lordship. In fact, the record speaks for themselves that for his past absence, whatever, he has already been punished, Your Lordship. And fourthly, Your Lordship, punishment imposed under section 11(1) of the CRPF is also not legally sustainable, Your Lordship. When charge under 11(1) cannot be framed, he cannot be punished under 11(1). Fifth, Your Lordship, I'm questioning the proportion, that the punishment imposed is not proportionate, Your Lordship. And last, there is non-application of mind, the part of the appellate authority in disposing the appeal filed by the petitioner, Your Lordship. Therefore, in my respectful submission, Your Lordship, the removal order dated 2010-2012 passed by the disciplinary authority on ground of non-appointment of presiding officer, and also the order dated February 2016 passed by the appellate authority on the ground of non-application of mind, Your Lordship. Both the order are liable to be questioned set aside, and the petitioner ought to be reinstated in service without consequential benefits, Your Lordship. I conclude. Much obliged, Your Lordship.
I will not take much time. First, Lordship, the petitioner all the remedies that is available to him under Rule 29 of the CRPF rules. There is a provision for revision.
Yesterday you had supplied one book. CRPF rules. This is your book, isn't it?
Lordship. In fact, CGC should be having it.
We don't have a book like this in the library.
No, Your Lordship. No, it's not. In fact, Your Lordship, when I was CGC, fortunately I could obtain that copy.
I have requested a copy, but they have not brought it to some of the rules and act.
Okay. We should have these books.
Rule 29. CRPF rules.
What is the Rule 29? Revision.
Yes, revision.
After appeal, revision.
After appeal, yes.
Yes.
Very good.
Yes.
A member of the force whose appeal has been rejected by a competent authority may prefer petition for revision of to the next superior authority. The power of revision may be exercised only when in consequence of some material irregularity there has been injustice or miscarriage of justice or fresh evidence is disclosed. So there's an alternate remedy logic for revision, but instead of going for revision, he has a cautious scope.
How, within what time should she go for revision? Any period prescribed?
It says when the appeal is rejected, the officer can make a revision to the next higher authority. And he has not made any such revision as provided under the rules.
No, that we've understood. Any time frame for that? There's no time frame.
No, no time frame as such.
Anytime they can prefer. What about appeal? 30 days. Appeal is 30 days, but even beyond 30 days, appellate
Worship,
authority may retain.
In the order, it is reflected. Order dated 28 February 2016, the impugned order.
Yes, what is
The
it
impugned order,
reflected?
it says, however, the appellant is at liberty to prefer a revision petition to the Inspector General of Police, Karnataka, Kerala, Sector so and so, who is the revisional authority against the order of the appellate authority. Accordingly, accordance with the provisions contained in Rule 29 of the CRPF Rule 1955, within a period of 1 month from the date of receipt of this order.
1 month.
Yes, Lord. In my affidavit, Lordship, you will see at page 41.
Yes, your affidavit.
My affidavit, Lordship, page 41 is annexure 11 portion is at page 41.
Yes, that I've
That's
seen.
paragraph 10.
So that I've seen. That's your first point.
Yes.
Then
During the inquiry, Lordship, the petitioner was given 15 days time to produce any documents in support of his claim. Thereafter, Lordship, another 15 days time was also given to you. So in total, it was 45 days, Lordship. My Lordship may see my
15 plus 15.
15 plus 15.
30 days.
30 days, Lordship.
So how I'll say 45 days.
I'm sorry, Lordship. Yes, too of time. So ample opportunity was given to him to place any documents, records in his support. But even after the expiry of 30 days, he has not produced any documents during the inquiry.
Where's the document?
Lordship,
Which shows that he was given 15 days time.
Lordship, my Lordship, I come to page 33. Start from page 32. Page 32. That is order dated 2010-2012. And relevant portion is at page 33. Lordship. C. Lordship. Yes. Charge official number so and so was directed by the EO White so and so dated 2/7/12 to produce necessary documents in his defense by 17/7/12 at 14 hours. After giving more than 15 days time to charge officials, re-examination was done by the IO, in which the charge officials expressed his desire to get the papers in his defense from home. As requested by the charge officials, 15 days more time was given to him so that the charge official could present evidence in his defense.
What is this document?
Documents is that the
No. This page 32. What is this? Office order? This is charge memorandum.
Yes, in the article of charges.
Article of charge.
No.
Okay.
So ample time has been given. Lordship. He has asked for 15 days time. He was given another 15 days was extended. Even after that, he could not produce the documents in his support.
Yes, then.
Lordship, he has accepted that he was guilty. If my lordship, I come to annexure 12 and 13, page 42. Page 42 and 43, lordship.
Of your counter.
Yes, my lord. This is the preliminary hearing proceedings, recording of the preliminary hearing. Lordship, I'll make your attention to page 43. Your departmental proceeding against number so and so by Sri Himraj Assistant Commandant so and so. After giving 48 hours time in respect of number so and after read out the charges of the delinquent, next procedure for preliminary hearing are as follows. The question asked by the EO and the reply given by the delinquent. Question 1. All the charges imposed upon you have been read out and explained to you on 19/3/2012 at 1 hours. Now, intimate whether you consider yourself guilty or not guilty in the charges imposed upon you by Article 1. Answer. Yes, I consider myself guilty. Question 2. Said whether you consider yourself guilty or not guilty in the charges imposed upon you by Article 2. Answer. Sir, I consider myself guilty in the charges imposed upon me by Article 2. Read and explain and admitted correct. So he has admitted to all the charges and yes, that he is guilty. So that is why the department presenting officer was not appointed. Even otherwise, the CRBF rule does not provide, there is no provision for appointing a presiding officer.
What was this stage? This page 43? What stage was this?
Before the charge.
Huh?
During the preliminary inquiry.
Preliminary inquiry?
Yes.
By that time, whether inquiry officer was appointed?
No.
Not yet appointed. Are you sure?
But this is conducted by the inquiry officer.
Inquiry officer.
Yes.
So inquiry officer was appointed.
Yes, sir.
He asked him questions in the preliminary hearing. He said, I'm guilty.
Yes.
So for that reason, he did not appoint presenting officer.
Yes, Lord. Even otherwise, as the rules does not provide any provision for.
Okay, doesn't provide.
Yes. Yes.
But next question is, did you stop there?
No.
Then
thereafter, inquiry was conducted.
Him saying guilty was not considered to be sufficient by you. You still proceeded to go ahead.
Yes, sir.
Isn't it?
Yes.
So if you decide to stop there and then, it's only an empty formality. If we go ahead also, he's guilty anyhow. He admits it. So you did not proceed to punish him straight away.
No.
You decided to go ahead again.
Yes.
Despite the fact that he pleaded guilty. So in that circumstance, are you not required to at least observe all the formalities?
Lordship, the rules does
not provide.
There is no provision for an inquiry officer.
Mr. Jamil had read up one circular.
Yes, Lordship.
You're not aware of about that circular? There is one circular which says that PO must be appointed. When I say you, I don't mean you in person. I'm talking about your CRPF authorities. Because circular will be for everyone. Yes, please carry on.
Lordship, the conduct of the petitioner in absenting himself without leave for 181 days. It is willful. Because his past conduct also shows that he has absented himself on several occasions. So this is not the first time, but on several occasions he has absented himself without leave. My lordship, can I come to page 32?
In order.
The article of judges. Page 32, the relevant portion is at page 34.
32 of your affidavit.
32 of my affidavit.
Yes.
Relevant portion, lordship, page 34. E, clause E. From the service book and the last 12 years service report in respect of so and so, it is revealed that he is in habit of OSL. And apart from the above, he was awarded punishment of confinement online for 3 times on various dates as under. So he's a habitual offender, lordship. This is not the first time that he has absented himself. But in earlier occasion also he is absented without leave. So he has willfully absented himself.
What do you mean by 7 days confinement to line? Confinement to line.
This is a military term.
You are CGC, you should know.
Maybe he was not allowed to go outside of the camp.
Okay. So for those irregularities or indisciplinary actions, he has been given this punishment.
Yes, Lord.
How do you bring that back now in this particular issue? That in the past years, on several occasions, he has been overstaying leave and he was also punished. So he's a habitual offender. Habitual offender, till that part it is okay. But to say that he willfully overstayed this leave because of his past conduct, is it possible?
It is not possible, but it shows that he is an habitual.
Ah, that is okay. Habitual, okay, nobody can deny. Many occasions he's been up. But to term that this particular absence of 181 days is willful because of his past conduct, that may not be the reason. That cannot be the reason.
You may say that in total he has absented himself for 181 days. He should have at least conducted his company.
That is true. I even asked also, why not?
But he has never given any information.
He was not marooned in an island somewhere that when there is no living species available nearby.
Tuli is in the address given it's written as Tuli.
Sorry?
Tuli is Tuli in Mokson district. So it's a urban area, in fact, was it?
There was a paper mill also there.
Paper mill, yes, there's a paper mill.
Paper mill was there, no more there. Now they are doing illegal mining. So it's well connected, isn't it?
In fact, Lordship,
Your lordship has gone on spot inspection.
No, I've been there. Tuli, I've seen Tuli while it was functioning. And one thing I'll just share you on the lighter side, or I saw one person counting paper. He was counting ream of paper, not counting one by one. He just took,
Yes, yeah.
he just took a bunch of paper.
Yeah, and then the
He said
exact.
50.
Yes,
And he took another one and said 50.
yes.
I did not believe. So I started counting one by one. It was exactly 50. Anyway,
Lordship, I fairly admit that the charges under section 11.1 has been wrongly charged. He has been wrongly charged under this section. And so he should have been charged under section 10, not section 11.1. So it's my pray that the present order may be quashed and a fresh trial may be set as per the direction issued by the Supreme Court in.
so, so you agree that it was a wrong section?
Yes, Lordship.
11.1 is the wrong section. No, what have you stated otherwise apart from that in your counterfeit?
Yes, Lordship.
Number one is, of course, he was willfully absent. Number two, he was given all the opportunity to produce the documents. 15 days, another 15 days, all 30 days, he could not produce anything. Then he has got his past conduct. Then you say that he did not apply for revision. What else have you stated?
Lordship, the company may affidavit at para 10, page 6.
Yes.
Para 10, Lordship. That with regard to the statement made in para 7, 8, 9 to the petition, whereas the opponent while relating the statement made in para 3 and 4, it is stated that the punishment awarded to the petitioner by the disciplinary authority commensurate with the gravity of offense and meet with the ends of justice. The petitioner, while refusing to appoint defense assistant at the time of DE, also admitted to his guilt on the charges framed against.
Just stop there.
Yes.
He refused to appoint defense assistant.
Defense assistant, yes.
How do you say that?
He was given the opportunity whether he would want to appoint.
Is there any document to show that?
There's no document.
Is there any document? Do you want to have or appoint defense assistant during the course of inquiry? No. No, sir. Okay, this is the one.
Nice.
Okay.
It is further stated that the petitioner in his appeal failed to bring any new facts to be intervened by the appellate authority. Therefore, his appeal was rejected, being devoid of merit by the appellate authority. Hence, the argument made by the petitioner is baseless, false, and misleading. In fact, the charges of desertion has been dropped because he has returned to the unit on his own free will.
Sorry?
The charges of desertion has been dropped against him because he has returned back to his base, to his unit on his own free will. So that is all my submission, Lordship. I leave it to your Lordship.
It's just allowed to reply first on revision, Your Lordship. Alternative remedy, Your Lordship.
Yes.
Your Lordship, yesterday I placed one citation, case law, first case law, that was Jammu and Kashmir, passed by the Honorable High Court, Jammu and Kashmir, Your Lordship, Muhammad Ashraf Shah.
Yes.
Lordship, it will be there, Your Lordship.
Yes.
May I take Your Lordship to para 68? That will be page 27. This is my pagination. Page 27. Para 68.
Yes.
May I read out? Another contention raised by the respondent is that the petitioner has a remedy of revision available to him, which wasn't available by him, and he jumped to the remedy of read and such and such. This is the objection raised, Your Lordship. Now, next page. Because revision that provision is quoted, reproduce, Your Lordship. Now, para 70.
It is a common notion that writs under Article 226 of the Constitution are not maintainable, where an alternative statutory remedy is available. The Apex Court and the High Court consistently deprecate the practice of filing writ petition in the High Court, where an alternative remedy has been provided under the relevant statute. But it is not an absolute rule of law, and there are valid exceptions where the writ petitions are maintainable in the High Court, and in such cases, the petitioner ought not to be relegated to alternative remedy. The Apex Court has consistently held that the High Court should exercise their discretionary jurisdiction in spite of availability of alternative remedy where the authority has acted without jurisdiction or in violation of principle of natural justice, or where virus of the act has been challenged, or for enforcement of the fundamental right. Like in the
So these are the exceptions.
Yes. Now, para 72, that is the willful decision or
Yes.
it will be tried to refer to willful corporation such as such. Under Article 226 of the Constitution, the High Court, having regard to the facts of the case, has a discretion to entertain or not to entertain a writ petition. But the High Court has imposed upon itself certain restrictions, one of which is that if an effective and efficacious remedy is available, the High Court would not normally exercise its jurisdiction. But the alternative remedy has been consistently held by this court not to operate as a bar in at least three contingencies, namely where the writ petition has been filed for the enforcement of any of the fundamental rights, or where there has been a violation of principle of natural justice, like this, or where the order of proceedings are wholly without jurisdiction or the virus of an act is challenged, Your Worship. Now, similar case has been referred, para 73, Harbansal Shani, Your Worship. The same repetition. In an appropriate case, in spite of availability of the alternate remedy, the High Court may still exercise its jurisdiction in at least three contingencies, similar, where it is for enforcement of fundamental rights, natural justice, whatever, same, Your Worship. So just because there's an remedy by way of a revision for the petitioner as per the rules 29, Your Worship, that will not be a bar for this honorable court to exercise writ jurisdiction under 226, Your Worship. Now, Your Worship, in the course of my submission, I have referred to the judgment order passed by the Honorable High Court of Jammu and Kashmir, Honorable High Court of Patna, and Honorable High Court of Manipur, Your Worship. Now, as regards the order passed by another High Court, Your Worship, may I just refer to one judgment, one paragraph, Your Worship, which is in 2008, volume 14 SCC 283. Para 23.
Yes.
Lordship has got it. Para 23, 8 line from top. We quite see the facts. Lordship has got it.
Yes.
We quite see the facts that the judgment given by a high court are not binding on the other courts, but at the same time, they have persuasive value. It's not binding, Your Worship. At least it has persuasive value, Your Worship. Why I'm referring to this, because I've relied on the decision passed by another high court, Your Worship. Now, another contention raised by the respondent is that sufficient time has been given, Your Worship. But sufficient time, like 30 days time has been given to the petitioner. But as I've submitted to Your Worship, whether that 30 days is sufficient under the given facts and circumstances, it will depend whether it's sufficient time has been given or not, will depend on the facts and circumstances of the case, Your Worship. Now, in the present case, at the cost of repetition, Your Worship, it was not that death certificate was not there, but it has been submitted to in the department where his deceased brother was working, and therefore petitioner could not obtain it within that time, Your Worship. So, considering that aspect of the matter, some more time could have been given by the inquiry officer, Your Worship. Now, as regards admission of guilt, which is recorded in the finding, it is admitted that yes, petitioner has overstayed leave for 181 days, Your Worship. But whether that unauthorized leave will amount to misconduct, whether it was willful, and therefore the absence will amount to misconduct, Your Worship. In the present case, Your Worship, as his absence was not willful, it will not amount to misconduct.
so as to what, to be given the, to impose the punishment of removal from service, your lordship. Now, and your lordship, the response counsel appearing for the respondent fairly admitted that the charges framed under section 11(1), your lordship, that is not, that is wrong, your lordship. In that view of the matter, your lordship, I pray that the order passed by this disciplinary authority as well as the order passed by the appellate authority, both the orders are liable to be interfered with, your lordship. And much obliged.
Please write down. Heard Mr. T.B. Jamir, learned counsel for the petitioner, and Mr. Gauhati, learned CGC, for all the respondents. Stop by filing this writ petition. The petitioner has challenged the impugn order dated 2010-2012 passed by the disciplinary authority, by which he has been removed from service with immediate effect. To stop, the petitioner has also challenged the order dated
The only month is mentioned, your lordship, February 2016.
nil February 2016,
16, your lordship, page 34.
by which the appeal filed by the petitioner has been rejected. To stop. Next para, the facts of the case. Essential for disposal of the instant writ petition may be noticed at the outset. Stop, the respondent authority concerned White memorandum dated nil.
The bottom is there, 15, your lordship. Bottom is there, 15 to 2012.
Where is that?
15, at bottom, page 15, page 15, your lordship. At the bottom, only 15 is clear, your
Okay,
lordship.
White memorandum dated 15 to 2012.
Your lordship.
Proposed to hold an inquiry against the petitioner who is employed as a constable,
Lordship.
bracket, general duty in the F/165 battalion of the CRPF under Rule 27 of the Central Reserve Police Force Rules, 1955. Bracket CRPF rules. To stop, along with the memorandum, statement of article of charge was framed against the petitioner. alleging that the petitioner has committed an act of misconduct in his capacity as member of the force under section 11 bracket 1 of the CRPF Act 1949. Give full form, CRPF Act. Full form. Bracket CRPF Act. To the effect that despite the fact that he was sanctioned 15 days of earned leave with effect from 1/9/2011 to 15/9/2011, he reported for he did not report back for duty and overstayed leave with effect from 5/9/2011 within bracket A/N close bracket without permission and sanction by the competent authority. To stop, along with the memorandum, statement of imputation of misconduct or misbehavior in support of the article of charge framed against the petitioner was also made. Besides enlisting a list of documents as well as list of witnesses through whom the article of charge framed was proposed to be substantiated. What is this page 26? Page 26. Oh, this is the impugn order.
India affidavit, Your Lordship, page 26.
In your writ petition, it's the impugn order.
The impugn order will be page 26. This is passed by the discipline authority. Writ petition, page 26. 2010-2012.
Next para, following the issuance of the memorandum of charge, the departmental proceeding was initiated. Is there any inquiry report?
No, it is, report is not there, but Your Lordship may kindly see page 26, para 4. On the basis of departmental inquiry report. Para 4, this is the finding. Page 26.
What did I say? And finalized by holding the petitioner to be guilty of the charge. Stop. Accordingly, the petitioner was removed from service by the impugn office order dated 2010-2012, as already stated here and above. To stop the appeal filed by him also being rejected, the petition is before this court. Next para, Mr. T.B. Jamir, learned counsel for the petitioner, submits that the grounds taken by the,
Your appeal has been preferred, appeal, statutory appeal.
yes, I have reflected that. Submits that the grounds taken by the petitioner can be broadly divided into 6 grounds. To stop, firstly, the charge under section 11.1 of the CRPF Act was wrongly framed. To stop, secondly, the respondent authority concerned failed to appoint a presenting officer, and for which reason the penalty inflicted upon the petitioner is vitiated. To stop, thirdly, the disciplinary authority as well as the appellate authority took into account the past conduct of the petitioner to punish him through the impugned order of
2010.
removal from service. To stop, the learned counsel further submits that the penalty, the charge against the petitioner having been wrongly framed, the penalty imposed upon him under section 11.1 is also not tenable. To stop, fifthly, the learned counsel submits that the penalty imposed upon the petitioner is highly disproportionate to the alleged offense to have been alleged misconduct, to the misconduct alleged to have been committed by him. To stop, lastly, the order passed by the appellate authority cannot be sustained in view of the fact that the said authority has failed to apply an independent mind to the appeal submitted by the petitioner by simply relying upon what was stated by the disciplinary authority. To stop, in support of next para, in support of the submissions made, Mr. T.B. Jamir, learned counsel, has relied upon the following authorities. Number 1, Mohammed Ashraf Shah versus Union of India and others, 2023 SCC online JNK 224.
The second decision, Your Worship. 2013 SEC online, Patna 360.
Number 2, Sudhanshu Shekhar Dio versus Union of India, 2013 SCC online Patna 360. Lalit Kishore versus Union of India and others. 2023, 6 GLT within bracket MN for Manipur 730. Krishnakant B. Parmar versus Union of India and another. 2012, 3 SCC 178. Next, Union of India and others versus Giriraj Sharma. 1994 supplementary 3 SCC 755. Next, Director bracket Marketing close bracket Indian Oil Corporation Limited and another versus Santosh Kumar 2006 11 SCC 147. And lastly, Pradeep J. Mehta versus Commissioner of Income Tax Ahmedabad 2008-14 SCC 283. Next para. The Learned Council referring to the memorandum of charge framed against the petitioner submits that charge has been wrongly framed under section 11 bracket 1 of the CRPF Act. To stop. Referring to the said provision, the Learned Council submits that section 11 bracket 1 comes under the head major punishments. To stop. Section 11 bracket 1 provides that the commandant or any other authority or officer as may be prescribed may, subject to any rules made under this act, award in lieu of or in addition to suspension or dismissal any one or more of the following punishments to any member of the force whom he considers to be guilty of disobedience, neglect of duty, or remissness in the discharge of any duty or of other misconduct in his capacity as a member of the force. To stop. However, the allegation and charge against the petitioner is for having overstayed leave for 181 days without permission and sanction of the competent authority. To stop, the learned counsel submits that the charge against the petitioner probably should have been under section 10 within bracket small m of the CRPF Act, and under no circumstance, the same can be under section 11 within bracket 1 of the said Act. To stop, in view of the departmental proceedings having proceeded under the wrong sections of law, the impugn orders are liable to be set aside and quashed. To stop, in support of his submission, the learned counsel relies upon the case of Mohammed Ashraf Shah Supra, wherein under similar circumstance, the High Court of Jammu and Kashmir held that the charge frame under section 11 bracket 1 of the CRPF Act, instead of section 10 within bracket small m of the same act, was bad in law, and therefore the impugn order passed against the petitioner therein was interfered with by the said High Court. Next paragraph. The learned counsel further submits that no doubt, Rule 27 of the CRPF rules provides for procedure for conducting departmental proceeding and is silent regarding the appointment of presenting officer. But having regard to Rule 102 of the same rules, it is explicitly clear that the rules applicable to central government servants, in absence of anything provided in the CRPF rules, should apply to those covered by the CRPF rules. To stop, therefore, non-appointment of the presenting officer by the respondent authority has clearly vitiated the impugn orders. To stop, the learned counsel, in support of his submission, relies upon the case of Sridhanshu Shekhar Dio Supra, wherein the Patna High Court held that in case of imposing of major punishment, public penalties in a departmental proceeding, appointment of presenting officer is a must. in terms of the CCS rules. And that in view of Rule 102 of the CRPF rules, appointment of presenting officer for disciplinary proceedings under the CRPF Act and rules is also necessary. Next para, the learned counsel similarly relies upon the case of Lalit Kishore Supra, wherein the High Court of Manipur, after taking into consideration the various decisions rendered by the apex court as well as of this court, came to the conclusion that non-appointment of presenting officer for a proceeding conducted under the CRPF Act and rules was bad in law. Next para. The learned counsel further submits that the respondent authorities failed to establish the fact that the unauthorized absence of the petitioner from duty was willful. To stop, in absence of such a finding, the penalty imposed upon him cannot be justified. Full stop, support has been drawn by the learned counsel from the case of Krishna Khan B. Parmar Supra, wherein the apex court, in the given facts and circumstances of that case, held that if the absence is the result of compelling circumstances under which it was not possible for the person concerned to report or perform duty, such absence cannot be held to be willful. To stop, the learned counsel submits that in the instant case, the petitioner, due to the illness and demise of his brother, could not report back for duty. And it was for this reason, that despite all attempts, the petitioner could not produce the death certificate before the disciplinary authority, since his deceased brother, being an employee of the forest department, all the documents relating to his service and his death had been submitted to the said department. To stop, although the death certificate was made available a subsequent stage and produced before the appellate authority, the same was not taken into consideration by the appellate authority, and instead the appellate authority summarily rejected the appeal of the petitioner. To stop, as such, the impugn orders are liable to be interfered with even on this count. Full stop. The learned counsel also submits that the number of days for overstaying leave may not be the main concern, but the reason why the employee concerned had overstayed leave would be a crucial determination for the authority concerned. Stop. Since the petitioner's brother had taken ill and ultimately expired, the same can be considered to be a sufficient cause for having been absent without authorization to stop. The learned counsel draws support of his submission from the case of Union of India and others versus Giriraj Sharma Supra. Next para, the learned counsel, by referring to the case of Santosh Kumar Supra, submits that the apex court, in the given facts of that case, found that the appellate authority did not apply its mind in passing the impugn order, despite the fact that there were materials placed before him for consideration, besides the process undertaken by the disciplinary authority. To stop. The apex court therefore directed the reconsideration of the case of the petitioner therein by the disciplinary authority afresh. To stop. In the present case, the learned counsel submits that despite the fact that the petitioner had submitted the death certificate of his late brother, the appellate authority did not take the same into consideration and mechanically passed the order of rejection. To stop. As such, the same should also the order passed by the appellate authority is not sustainable and should be set aside. What is this 2008?
2014 SCC 283, Your Lordship. Judgment order passed by another High Court has precisive value.
The learned counsel submits that although some of the cases relied upon by him are the judgments passed by other high courts, the same although may not have a binding effect, but definitely it will definitely have a persuasive value to the instant case. And therefore, this court may consider the authorities relied upon by him. In this connection, the learned counsel refers to the case of Pradeep J. Mehta, Supra. Next para, the learned counsel, Mr. T.V. Jamil, submits that under the given facts and circumstances, the impugn orders passed are not sustainable in law and the same should be set aside, and the petitioner be reinstated with all consequential benefit. Next para, Mr. Gauhati, learned CGC, by referring to the affidavit opposition filed by the respondents on 8/8/2023. Submits that, no, not 8/8. Change the date, 10/4/2023. Submits that before filing the instant writ petition, the petitioner has not exhausted the remedy available to him. To stop referring to Rule 29 of the CRPF rules, the learned counsel submits that there is a provision for filing revision petition. To stop, the petitioner was also the appellate authority also in its order had indicated that the petitioner could file a revision petition against the rejection of his appeal within a period of 30 days. To stop, however, for reasons best known to the petitioner, he failed to avail for the remedy, and therefore, in the absence of the provision of Rule 29, the writ petition is not maintainable. Next para. The learned counsel, the learned CGC further submits that the petitioner was given sufficient time for producing any document in support of his case. To stop, initially 15 days time was granted, and thereafter on his prayer, further 15 days time was granted, 30 days in all. But however, the petitioner failed to produce any document in support of his claim that his brother had expired. To stop, therefore, the petitioner cannot have any grievance in that regard. Next para, the learned CGC submits that during the preliminary hearing, the petitioner had also admitted his guilt, that he was unauthorizedly absent for 141 days without permission from the competent authority. To stop, despite that, the respondent authority decided to proceed with the inquiry, wherein the petitioner was given all the opportunity to defend his case. To stop, despite this, despite the same, the petitioner failed to justify the reasons for his absence from duty. To stop, accordingly, the disciplinary authority after finding him guilty of the charge, rightly issued the impugned penalty of removal from service. To stop, the learned CGC also submits that the petitioner, in fact, is a habitual absentee, which can be clearly seen from the memorandum of charge and the documents enclosed therein. And documents enclosed along with it. To stop the petitioner belongs to a disciplined force, and therefore his conduct, and for his conduct, the impugn order has rightly been issued. To stop, he thus submits that the writ petition should be dismissed. Next para, I have considered the submissions made by the learned counsels for the rival parties and I have perused the materials available on record. The reason why disciplinary proceeding was drawn up against the petitioner was because of his overstay of his earned leave. To stop, the petitioner was granted 15 days earned leave, but he remained absent for 141 days. After the expiry of the earned leave that was granted to him. To stop, rule 10 within bracket small m of the CRPF. So this is section 10 within bracket m of the CRPF Act provides that every member of the force who absents himself without leave or without sufficient cause overstays leave granted to him shall be punishable with imprisonment for a term which may extend to 1 year or with fine which may extend to 3 months pay or with both. To stop, in the instant case, the petitioner has been proceeded against by charging him under section 11 bracket 1 of the CRPF Act. To stop, section 11, as already stated, provides for minor punishments. Stop section 11 bracket 3 of the CRPF Act provides for 3 types of punishment, and none of the punishment prescribes for removal from service. Stop. Therefore, there is substance in the submission made by the learned counsel for the petitioner that the petitioner has been proceeded against under the wrong sections of law, and that he could not have been punished under section 11 bracket 1 of the CRPF Act by removing him from service. Which was that law?
JNK, Your Worship.
Next para. In a similar circumstance, in a similar facts and circumstance, the High Court of Jammu and Kashmir had the occasion to deal with a case of similar nature, wherein a CRPF personnel who ought to have been charged under section 10 bracket small m of the CRPF Act, amongst others, was charged under section 11 bracket 1 of the CRPF Act. Under the circumstance, the High Court concluded that the impugned order of termination imposed upon the petitioner concerned was not sustainable, and the same was set aside. The High Court of Jammu and Kashmir had also the occasion to deal with the issue as to whether the powers of the writ court under Article 226 cannot be availed of on the ground that there was an alternative statutory remedy. To stop answering the question in the affirmative, the High Court, by relying upon the case of Whirlpool Corporation versus Registrar of Trademarks, Mumbai, 1998, 8 SCC 1, and the case of Harbanslal Sahnia versus Indian Oil Corporation Limited, 2003, 2 SCC 107, came to the conclusion that as already decided by the apex court, a writ petition cannot be rejected solely on the ground that an alternative statutory remedy was available when the petitioner concerned seeks for enforcement of any of his fundamental rights, or where there is a violation of the principles of natural justice, or where the order or proceedings are wholly without jurisdiction, or the virus of an act, capital A, act, is challenged. Stop. In view of no, in view, cancel that. This court is also in respectful agreement with the decision rendered by the said High Court. And in fact, the law laid down by the apex court would be binding upon all the other courts. In view of article, what? Somebody? Article so and so of the Constitution of India.
Your Lordship, 141.
141.
141.
141,
Yes,
right.
But you're subject to this thing.
Yes, we'll check it out, no problem. We'll stop. Next para. The next important question raised by the learned counsel for the petitioner is that the presenting officer, having not been appointed, the disciplinary proceeding, the entire disciplinary proceeding stands vitiated, requires the attention of this court. To stop, it is not in dispute that the CRPF Act and rules does not provide for any provision for appointing a presenting officer. To stop, it may be seen that the High Court of Manipur in Lalit Kishore Supra had the occasion to deal with a similar matter. And reference to the judgment of the apex court as well as this court was also made. To stop, the High Court referred to the case of Union of India versus Ram Lakhan Sharma, 2018, 7 SCC 670, and clarified that non-appointment of presenting officer would vitiate the inquiry proceedings under Rule 27 of the CRPF rules. Where is that circular thing which you had read out? Circular.
Circular, Your Worship.
No.
I have SSS of pagination GLT different, Your Worship. That would be in para 7, Your Worship.
Para 7 of GLT.
Yes, para 7 of GLT, it will be sub para. So far as the non-appointment of presiding officer, Lordship has got it. Mr. Bobby Bobsambam is there, Your Lordship? GLK para 7.
Yes, yes.
So after that, I think here I have I have SCC, that is what we. So far as the non-appointment of presiding officer is concerned, the respondent have not denied the fact that no presiding officer was appointed as such. Mr. Bobby Bobsambam Dalnas is placed before a court as circular number.
To stop. In the said judgment, one circular, that is circular order number 07/2018, dated 23/5/2018, issued by the Director General of CRPF, was also referred to, wherein it was provided that after the evidence on behalf of the prosecution and defense is completed, the inquiry officer shall hear the presenting officer or permit him oblique her to submit written brief within a period not exceeding 10 days. Stop. Inquiry officer will thereafter forward copy of the same to the charge officer for submitting his defense brief, if any, within a period not exceeding 10 days. Now, regarding that TCS,
That Patna High Court CCS, the copy which I have furnished.
Patna High Court.
Patna High Court. Page 5. Third para.
It may further be noticed that the High Court of Patna in Sudhanshu Shekhar Dio Supra had also referred to a decision of this court in writ petition civil number 297 of 2002. Wherein it was held that although Rule 27 of the CRPF rules may be silent about appointment of presenting officer, Rule 102 of the CRPF rules provides that one can take the aid of CCS rules for compliance of the principles of natural justice. Stop. Rule 102 of the CRPF rules may be reproduced hereunder for ready perusal. Then you write 102. First you open bracket and now open inverted comma, then 102. Then heading other conditions of service, colon. Next line, the conditions of service of members of the force in respect of matters for which no provision is made in these rules shall be the same as are for the time being applicable to other officers of the Government of India of corresponding status. Close inverted comma, full stop. Next para. In view of the above provision, it goes without saying that even in the absence of any provision for appointment of presenting officer, it would be necessary for the authority concerned to appoint a presenting officer to present the case on behalf of the department, public organization. Next para. In view of what has been stated above, this court finds that the respondent authorities could not have proceeded against the writ petitioner under section 11(1) of the CRPF Act, much less, impose a major penalty of removal from service under the said provision. Full stop. In other words, the impugned orders passed by the disciplinary authority as well as the appellate authority are found to be not sustainable in law. To stop, having come to such a conclusion, it may not be necessary to refer to the other, to examine the other arguments made by the learned counsel for the petitioner. To stop, in the result, the impugned orders dated
2010-2012.
2010-2012 and the 2010-2012. This is
Order.
annexure.
The NH this is part of this thing. Annexure A3, page 21.
Annexure A3 and the order dated
That is dated nil February, Your Worship, February 2016.
dated nil February 2016 within bracket annexure A5 are hereby set aside. Next para. This court is not unmindful of the fact that the petitioner belongs to a disciplined force, and therefore hereby gives liberty to the respondents to proceed against the petitioner afresh in terms of as per law. Within a period of 3 months from the date of receipt of this order. It is made clear that if the respondent authorities decide to proceed in the manner as directed herein, the petitioner shall be treated to be as under suspension and will be entitled to the remuneration of a suspended employee. To stop. In case the liberty granted is not availed of within the period prescribed, the petitioner shall be reinstated into service. To stop, the respondents would be at liberty to decide the entitlement of the petitioner on his reinstatement as per law. With the above observation and direction, the writ petition stands disposed of.
Deeply obliged, Your Worship.
Lordship, I beg to mention item 54, Your Lordship, the supplementary hearing list, Your Lordship. Your Lordship, the coming 3 weeks, I have some personal difficulties. If the matter will be fixed on 12th of March, Your Lordship,
Item
54. 54. My friend, Mr. Gauhati, he is appearing. for the
Okay, as paid for by Mr. TV Jamir and not objected to by the other side. List the matter again on
12th March.
12 March.
Oblige, Your Lordship.
Yes, there is one matter left. What is?
Admission, for admission, item number 43.
Mr. Jamir was here,
Item 52.
52. We are out of time, so what to do?
Lordship, there's a time constraint. It will be taken up on Thursday, Your Lordship.
Thursday. I don't know, if possible. You may take your chance if you want to, but because we have division bench tomorrow, and surely there'll be something again.
If we listed any of this, Your Lordship, the time
Okay,
permits, then we can take up for a hearing.
okay, 52, right? As paid for is the matter again on Thursday. That is 15th, is it?
Yes, Your Lordship.
15th of February.
Much obliged.
Any other matter?
Your Lordship, item number 43 was not called out, Your Lordship.
43. Yes. But this is hearing matter, isn't it?
Yes, Your Lordship.
What to do?
Kindly be passed over on Thursday, Your Lordship.
Thursday?
Yeah.
Okay, as paid for, this is the matter again on 15th February. Mr. Jamir, I'll keep this book for some time. Okay.
I will collect it from the registry. Deeply obliged.